Yay, oh yay, oh yay. Anyone having business before the King's Justice of the Superior Court of Justice shall be heard. Long live the King, the Honorable Justice presiding. You may be seated.
Good morning, all.
Good morning.
Good morning, Justice Hennessy. We'll be calling Fred O'Riordan to the stand. First, I wanted to mention to you that we have reached agreement on the qualifications for the next witnesses next week, Professors Eric Kersner and Lawrence Booth.
Thank you.
And I also wanted to ask the court's permission to split this examination like we did yesterday, where my colleague, Ms. McNamara, will be leading Mr. O'Riordan through his credentials.
Very good.
So then I'll pass it over to Ms. McNamara and we'll call Fred O'Riordan to the stand.
Oh, sorry.
Yep.
Fred O'Riordan, F-R-E-D-O''R-I-O-R-D-A-N.
Thank you. Do you solemnly affirm that the evidence to be given by you to the court touching the matters in question between the parties will be the truth, the whole truth, and nothing?
Thank you. Great, thank you.
Good morning, Justice. Before we get started with Mr. O'Riordan's qualifications, I want to ensure that the court has a copy of the agreement to qualifications, which I believe are coming up to you right now.
Coming up. Thank you.
And I would like to have these entered, I think, as exhibit number 31,
33 and 34.
33 and 34. Perfect. Oh, actually, I believe it's just one exhibit. So just
the qualification.
number 33.
Okay.
Yeah.
So both documents are.
Yeah.
And I have before me the jointly authored reports. Do I need anything else?
Nope, I see you also have the demonstrative slides in front of you, which Miss Evans will enter.
Very good.
Oh, okay.
Perfect. Thank you. So, Mr. O'Riordan, good morning.
Good morning.
Few matters of housekeeping first. I want to confirm with you that your first report, co-authored with Professor Mintz, entitled Determining the Value of Net Resource Revenues in the Robinson Treaty Territories. Is that correct?
That is correct.
Okay. And we have a second report here as well. This is your SIR reply report with Professor Mintz in response to the expert reply report of Joseph Stiglitz and David Hutchings and the expert reply report of David Hutchings. Is that correct?
That is also correct.
Okay, I will be passing these up to Mr. O'Riordan so that he has them for the record. And these are already marked as exhibits from earlier this week.
Thanks.
Thank you. And just to backtrack here for a moment, Mr. O'Riordan is qualified as an economist, as an expert in tax policy, tax administration, and public finance, with specific expertise in benefit cost analysis and socioeconomic evaluation of government programs and policies. Those two reports there, Mr. O'Riordan, together they form the contents of your opinion, correct?
Yes, that's right.
Excellent. And you signed a document to abide by Rule 4.1 of the Ontario Rules of Civil Procedure, which in sum promises that you understand your duty is to do your best for the court today.
That's right. And I do. That is my understanding.
Excellent. Okay. Could you please explain or highlight your education for us?
Well, I completed an honors BA in economics at Queen's University and a master's in economics at Western University, Queen's being in Kingston, Western being in London, Ontario.
Excellent. And I understand that today you're the national leader in tax policy and the Canadian leader in economic and analytical services at Ernst & Young. What do these roles entail?
Right. So yes, I wear two hats in my roles at Ernst and Young. One is drawn from my tax experience, as you indicated. Well, we haven't quite got there yet, but I have I have extensive tax experience in my public service career. And when I joined EY, I did primarily tax policy work. Um, in the course of the first couple of years, it was recognized that I had a lot of expertise in economics, and so they decided to give me some additional responsibilities in that area because a lot of my work was headed in that direction anyway. It was economics with sometimes with a tax component, but more often than not. So I do both of those roles. The tax policy role is partly internal. I mean, helping tax partners interpret, understand government, not just legislation, but the operation of government, particularly the Canada Revenue Agency where I used to work, and also client related. And it's a mix of both public and private sector clients. In other words, I advise clients about their responsibilities to comply with Canadian tax legislation and so on. But I would say more often than not, I've been working with public sector institutions on tax related matters. An example would be the City of Vancouver with its empty homes tax, where I've had a number of engagements providing advice from the conceptual beginning of the tax to the administrative issues that the city has run into. And I'm continuing that. I'm on a current contract doing that as just as an illustration. The economics part. Oh, I'm sorry. Yeah. The economics part is more along the lines of doing economic impact analysis. That's a lot of the workload where a client would want to know what their contribution is, let's say, to the Canadian economy in terms of employment generation, national income, GDP, tax revenue, and so on. There are methods that we use to make a determination of what those contributions are. Companies clearly are interested in that, in part to demonstrate, their value to the Canadian economy, and sometimes in relation to representations that they might make to government for certain changes that would benefit them. In other terms, known as lobbying sometimes. And so sometimes you're in situations where if you're providing advice to public office holders, which I used to be a public office holder, on the other side of the table, you're bound by certain rules under the Lobbyist Act for registration and so on. So those are just a few examples, I guess, to illustrate. There's a considerable variety in the work that I do.
Okay, excellent. And I know you mentioned the Vancouver vacancy tax. Can you give us another example of recent work you've done for EY?
One that I guess that comes to mind, I'm not anticipating some of these questions either. One that does come to mind, I think, is a report that Dr. Mintz and I co-authored on a new tax called the luxury tax. We did that last year. The client was the boating industry, the National Marine Manufacturers Association of Canada, where we estimated what that tax would do, not just in terms of generating revenue for the government, but what it meant in terms of the impact on companies and the way some of their customers would react to the tax. Taxes almost always have a behavioral impact. And so as economists, we understand what happens on the demand side of the market, what happens on the supply side, and so on. So we co-authored a report that involves some quantitative analysis of what that tax would do.
And you've mentioned that before coming to Ernst & Young, you were a member of the Federal Public Service. For how long?
For 33 years.
33 years. Okay. And what was your role within the Federal Public Service?
Oh boy, 33 years. So should I go forwards or backwards in terms of
Just give
experience?
us the
highlights?
Highlights, yes.
So when I left the federal government, I was the Assistant Commissioner of Appeals at the Canada Revenue Agency. I was in that role for 3 years, and that role involves the main responsibility is around objections and appeals to assessments of taxation by the agency. So I kind of had two different roles, I guess, in that job too. At the objection stage, appeals officers are meant to review the assessments of the agency that come from the compliance side of the organization. And we have delegated authority to vary or vacate these assessments. So we can make, if we felt that assessments weren't in accordance with the laws interpreted by the CRA's rulings directorate, and it wasn't a principled outcome as far as the assessment is concerned, we would have authority to vary or vacate it. We also have authority under a different legislative provision in some of the statutes to grant relief. And the relief provisions don't extend to tax relief, but they do extend to penalties and interest. And so we would exercise those roles. In the litigation side, our role's quite different, actually. In litigation, if the taxpayer isn't satisfied with the outcome of the objection, then we revert to taking a position with the agency and defending the assessment, because we have already passed judgment that it is in accordance with the law. And sometimes taxpayers can jump immediately to the tax court. That's always where they start, in the tax court, and then they can be appealed to the Federal Court of Appeal or the Supreme Court. But in that case, we're actually defending the assessments. So that's sort of the and I won't get into the weeds with too many other jobs because it will take too long. But I was, prior to that, prior to being appointed Assistant Commissioner of Appeals, I was the Director General of International and Large Business in the compliance program side. So that was the pointy end of the stick. I mean, I was really functionally responsible for all of the large case file assessments, large corporations, wealthy individuals, aggressive tax planning, and so on. And in that role, sort of analogous to the appeals role that I had later on, the agency organizationally parks competent authority services there. So for some of those assessments where they're international in nature, the role of that organization inside my larger branch, Competent Authority Services Division.
I'm sorry. Can you say that?
Okay, I'm sorry. Yeah, I know I'm
Inside the larger branch?
inside the larger branch, which is the Compliance Programs branch. There's the Competent Authority Services Division, and its primary role is to administer the bilateral tax treaties that Canada has signed with many other countries, many other jurisdictions. And one of the main roles, I would say the main role of the treaties, is to relieve double taxation. And it's probably good to mention that and park that thought, because I'll talk a little bit about that later in my comments around transfer pricing. So those are the last two jobs, and there were many, many more before them at the Canada Revenue Agency, and before that at the Office of Comptroller General, and before that at Treasury Board Secretariat, where I did a lot of the economic impact analysis and benefit cost analysis. And I started, my first organization was Agriculture Canada, actually. So 33 years.
Excellent. And I understand that today you are a member of the International Fiscal Association, Canadian Tax Foundation, and CPA Canada's Tax Policy Committee. What do you do as a member of these organizations?
It sort of depends. I mean, it depends on the organization and what roles I've been asked to play. So I'm probably most active on CPA Canada's Tax Policy Committee, which is a bit ironic because that's the professional accountants of Canada. I'm not an accountant, I'm an economist, but there's value added in having an economist involved in some of the policy deliberations there. So I'm more active in that, and I have assisted the president of the CPA in some reform exercises that the organization is going through, because there's a lot of changes in the accounting, not so much in the accreditation side, although that's also a moving target, but also their roles and responsibilities. The others, CTF, or the Canadian Tax Foundation, I've occasionally spoken, and International Fiscal Association. I used to be a governor when I was with Revenue Canada. Each member country, the International Fiscal Association is a fabulous organization because it's the one place that brings together tax policy people in government, tax practitioners in the private sector, and also tax judges who attend. And so we're not always able to attend the same functions, but there is a good, sort of exchange of issues and ideas and challenges, all with the idea that we're trying to enhance compliance with the tax system, be it domestic or international. So I used to be a governor, but I'm not active in that role anymore because each country had two governors, one from CRA, one from Finance Canada in our case. So less active in those.
Okay. And I understand that you've also served as a consultant to the IMF. What
Yes.
did that entail?
So one of the largest contributors to the IMF is Japan, and the IMF keeps what they refer to as the Japan sub-account, and those are monies that Japan has given for development projects internationally. Periodically, like most governments, they want to review and evaluate their programs to determine, are they meeting their objectives? Should there be some improvements or whatever? And so a colleague of mine, Ken Watson, who is a consultant with Rideau Research Associates in Ottawa, wanted, he won a contract and he needed some technical assistance on various aspects of the IMF's review. And so I was engaged to do the fiscal affairs chapter in the evaluation. A former colleague of mine at the Office of the Comptroller General named Toru Uno, who's a program evaluator and was born in Japan, so speaks fluent Japanese, brought those two skills to the table. And Munir Sheikh, who used to be the chief statistician.
Sure, when you give a proper name, maybe you could spell it for the record,
Okay.
for the reporter.
So Toru Uno is Toruuno. Munir Sheikh, Munir, and you'll have to trust me. I apologize. I shouldn't laugh, but I know Munir well, but Sheikh perhaps, to be confirmed.
We
Okay.
can confirm
Okay.
that.
Okay.
Okay, excellent. Thank you. And-
So Munir's contribution was in his area of expertise as well.
Okay. And have you been to Sudbury before?
Yeah, not in a long time. My wife comes from Sturgeon Falls, and we're more often in North Bay and Sturgeon, and I'm always kind of anxious to go those extra few miles to Sudbury because when I was a student, I spent 2 summers here. I worked underground for Falconbridge at the time in the Strathcona mine.
Now you're really establishing your credentials.
Thank you. I worked in the Strathcona mine and then the East mine in the Falconbridge town site. And to Justice Hennessy's point, I did get some early exposure to mining technology, which was amazing underground. The technology in a Canadian hard rock underground mine is quite amazing. That stayed with me. But the real life's lesson that I learned here in Sudbury was Sudbury in the 70s was a booming town and it attracted a lot of immigrants, and most miners were either first or second generation Canadians. And I'd never been exposed to that. I grew up in a town called Madoc in Hastings County, which has a mining tradition, but not like Sudbury's. And when you're a university student starting in a mine, you're exposed to English, French, Ukrainian, Polish, a lot of different nationalities, a lot of different cultures. It was a real melting pot, which I'd never been exposed to. And the life's lesson was, not surprisingly, if you're a university student, you have to win respect and trust. They know that you're never going to spend your lifetime working underground like they do. And so it's not that you're shunned, it's just that there's a little bit of a separation. And over the period of a month or 2 months, you start to feel the kinsmanship and the teamwork. And it's the teamwork side that stayed with me all my life in government, where I've been working, but also the multicultural side, which was quite interesting. Sorry to go off on a tangent, but you did
Well,
ask.
Welcome back.
Yeah, thank you.
And my last question for you is, I understand you have specific expertise in the evaluation of government programs and policies. Can you explain how you came to that expertise?
Yeah, so part of that comes from my educational background, because I did specialize in public finance, and that's where, that's where that bucket of expertise is found. That's where you learn it. Back then, there wasn't a lot of coursework though on things like benefit cost analysis. So I learned it, learned by doing really. Uh, First at Agriculture Canada, because we were doing a benefit cost study for the Treasury Board on a disease control program. It was called, the disease is brucellosis, and we had an outbreak in Canada which had an immediate effect on the market because the United States would no longer import Canadian cattle. So I did the conventional, evaluation, the baseline scenario, and so on. But in addition, I did some measurement of welfare losses due to trade restrictions, and that was published. I worked in the economics branch, and my assistant deputy minister was sufficiently impressed with that work that he suggested that I submit it, and it was used as a case study in a well-known public finance textbook many years later. 25 years later, I think I came upon it quite by accident. I didn't even know they were using it. So that was my first experience in learning benefit costs. And then because of that, there was a group in the Treasury Board Secretariat called the Technical Advisory Group on Impact Assessment. And I said that pretty fast, I know. A Technical Advisory Group on Impact Assessment. I interviewed and was hired to work there. And we were doing, this was a time of regulatory reform. There was a lot of interest in doing economic analyses ex ante before regulations are passed, to try to sort of demonstrate, is there like a cost benefit rationale for regulations, to minimize, because regulations impose costs on the economy. You want to be able to justify that there's a public policy purpose being served. And so I did a case study for them. And then within a couple of years, I became the group chief there. So that was responsibility for guidance for all departments and agencies subject to this policy, this socioeconomic impact analysis policy. So we wrote guidance on that. We wrote a Treasury Board benefit cost guidance. So that's a long, I'm sorry, but that's where I gained the experience. And then after that, it's been just practical applications of that, which I continue to do to this day. As I mentioned earlier, when I first joined Ernst & Young 13 years ago, they recruited me from the tax side. But when it became apparent that I could do this other work, they decided I should wear that hat as well, because there are, there's a real demand for those sorts of services in the market. And that for me was kind of exciting, because I'm an economist, at heart, but a lot of my public service career was spent in executive roles where you're not near the coal face or the ore. and this put me back using my tools again.
Excellent. Thank you, Mr.
Could I
Reardon.
just ask one question? You've used the words benefit cost in my
Yeah.
economist reduced life.
Yeah.
I have heard the phrase cost benefit. Is there a difference?
No, and I like your question, because that used to come up from time to time. Which of these expressions is more appropriate? And most of us sort of settled on benefit costs because it's the net present value of the difference between the two, and it's usually the net benefits. You want to end up with positive net benefits, but there's no difference at all. Sometimes you see it with a hyphen, sometimes not.
Thank you.
Yeah.
Thank you, Mr. Reardon. I will turn it over to my colleague, Ms. Evans, to continue.
Mr. O'Riordan, our joint challenge today is going to be speaking slowly enough for Ms. Martineau, the reporter,
Yeah. Understood.
because I know I have that problem as well. So we'll do our best to keep an appropriate pace. I understand that you've prepared a slide deck, which is titled Trial Demonstratives of Fred O'Riordan, and I believe everybody has a copy of that. I'd like to ask that that be marked as the next exhibit. I think that would be exhibit 34.
Correct.
Everyone okay with this?
As long as my friend assures me that either has testified to it in his report or will testify it on the stand. Let's just mark it as, if my friend can provide that assurance, mark it as a numbered exhibit.
Thank you. I think perhaps Mr. O'Riordan would be best to provide that assurance.
Or
Um,
just turn our minds to it at the end of your examination.
Sure. Mr. O'Riordan, you have a copy then in front of you, a hard copy,
I have a hard copy and I
Great.
have the monitor
as well as
screen
up on
too.
the screen. And did you prepare these slides yourself?
Yes, I did.
All right. And are these slides based on your portions of the reports that you co-authored with Jack Mintz?
Yes, that's correct.
Why don't we get started then with, I see that the first slide, aside from the title page, sets out your assignment. Your colleague, your co-author, Professor Mintz, went through this for us earlier this week. So I think maybe what we'll do is a jump ahead then. I see your third slide lists the reports, which Ms. McNamara has already gone over. So why don't we start on the fourth slide? If you can explain for us what parts of the joint report with Professor Mintz that you'll be dealing with in your testimony today.
Yes. So on this first slide, you'll see there are basically three different areas that I'll focus on. The first one is highlighted in red, and I mention that because you'll see as we go through these slides periodically, there is a placeholder slide just to keep our place and remember where we are in relation to the overall story. So starting with the approaches to compensation. The second area is the frameworks that could be used to determine the sharing of resource rents or net crown resource revenues. And the third and final bucket is evaluating deprivation using concepts of relative wealth or income. And in each of these line entries, I've made reference to the paragraphs to link them back to our main report.
Thank you.
Sorry, Ms. Evans, should I also just enumerate? So the first area, because I'll be going through those in order. The first one are different approaches to compensation. And I want to start off with the conventional approach and then the approach that involves economic rents and sort of a critique of that second approach.
Great. I think then we can probably start on your slide 5 with that conventional approach you spoke about. Would you like to take us through your evidence on that?
Yes, thanks. So this slide, I really wanted to sort of set the stage for the commentary that follows. And this matter is complex. There's no question about that. The documentation, the economic principles and so on are, and even the proceedings that I have managed to watch. And preparing my slides, I thought it would be useful to the court in my role and my responsibilities to the court to sort of step back a little bit and state and remind ourselves just in fairly straightforward, simple terms, what the conventional approach is to determining damages and then determining appropriate compensation, and then move on from that to the specifics of this case, because this case is far more complex than an ordinary case of damages. And I have done evaluation work in ordinary compensation cases involving damages. As an example, the Insurance Corporation of British Columbia, I've done work for them looking at and critiquing economic impact analyses of damages from motor vehicle accident victims. They don't do that anymore because BC in the last couple of years has adopted no fault insurance. But up until that time, there was a lot of litigation before the British Columbia Supreme Court involving cases like this. So typically you see that there's an accident and there's a victim, and that accident has caused damage to the victim. Typically it's, let's keep it simple again, just loss of income. The victim is in some ways incapacitated, not able to earn the same level of income that he or she could have earned had the accident not happened. And I'll come back in more detail, but I just wanted to lay that down as sort of a simple example In this case, part of the complexity is that there was damage. There's no question about that, but it was caused by the Crown not honoring its treaty obligation. And that obligation was to periodically augment annuities to the plaintiffs when it could do so without incurring any loss. So it's a somewhat different scenario, but the principles are exactly the same. You're looking at what happened and what should have happened and what could have happened. You want to have a plausible alternative scenario, and then the compensation falls nicely out of that as the difference between the two outcomes.
Can I just ask, are you giving a legal theory or an economic?
An economic theory.
Okay. So it's an economic theory that,
Well, it's an
that you
economic.
look at the but-for situation.
Yeah.
Okay.
It's, I would call it more an economic methodology or an approach than a theory in this case. There is a lot of theory that comes in later, particularly when we get into the alternative approach of using economic rents. But for the most part, this is pretty straightforward stuff. And, you know, I mean, with respect, because I'm not a lawyer and I have no expertise in law. I've worked with lawyers and accountants all my professional career, but that's not the approach I take. It's an economic approach. But I think there's probably little or no difference between this economic approach and the legal approach, because we're following what's set out in the law. You know, the plaintiffs have access to recourse, and they utilize that, and the purpose is to keep them whole, or to restore, you know, whatever they've lost because of the fault of another party, whether it's a motor vehicle driver or whether it's a government. If that helps. One of the additional factors that weighs here that wouldn't ordinarily weigh is consistent with the Ontario Superior Court decision and the subsequent decision of the Ontario Court of Appeal. The decision is directed to take into consideration not just those ordinary factors, but also the relative wealth and needs of the different communities, what that decision meant was the Indigenous versus non-Indigenous communities. So that's an additional factor that has to be brought in. And I'll talk a little bit more about that later. I think that's it for the slide 5.
Do you call that a different factor or a different approach?
I would be more inclined to call it a different factor, because the approach is the same. The only difference is that at the end of that process, you factor in a consideration of relative wealth in determining what the financial, you know, compensation would be. So I don't see it as methodologically any difference, and I don't treat it any different in the comments that Dr. Mintz. I keep saying me, but I really should be saying we, because Dr. Mintz and I both collaborated on this. But I don't see it factoring in any differently in the conventional approach, which you'll see later. I think is the superior approach, using net Crown resource revenues, or the alternative approach using economic rents. In either case, at the end of that process, then you've also got to give thought and consideration to deprivation and the difference between the relative wealth of the two communities.
Mr. O'Riordan, I see that on that slide that we're, slide 5, you actually have a quote from that Ontario Court of Appeal decision. And I think maybe this speaks to what you've been talking about. Perhaps you could go through this quote for us, the last bullet point on that page 5.
Sure. And in fact, I thought I did read it, but perhaps I didn't. So the Court of Appeal has instructed that those augmented annuities should be, and I quote, not only based on the extent of Crown revenues, but also with reference to the relative wealth and needs of the different communities.
And I think the point that you were getting at was that in your answer to Justice Hennessy, that in your view, there's 2 components to it. The first component being determining the but perhaps I'll let you explain it again. The two components that you read out of this quote from the Court of Appeal, the two components of the analysis, can you just describe those again?
Sure, and I think it becomes clearer because I'm going to go through in the subsequent slides, just, the methodological approach and the differences. But ordinarily, there isn't this additional consideration outside the scope of the damage that actually happened to take into consideration another factor. Usually, it's what the aggrieved party has lost and how you keep that party whole. And it could be a variety of things. I used foregone income as an example, but it could be loss of mobility, anything.
Yeah, I'm just going to ask you to slow down on that because I'm
Okay.
trying to absorb what you're saying,
Right,
because it wouldn't, I keep coming back to it, wouldn't be, as you say, the conventional approach. You don't take an accident victim, an MVA victim, and look at how their neighbor did.
yeah. That's actually, I think that's helpful because that's a good analogy. So just to explain that accident victim, the way and it's often actuaries or economists who do these calculations, but they do them actuarially. You look at the person's occupation, and there's a lot of rich data on this that is kept on different occupations by age and gender, and you can
Because there's a difference.
yeah, there is, it's still a gap. Sorry, it's narrowing. So you calculate that, but you don't take into account, nor should you take into account, the relative wealth differences between that individual or say the perpetrator or the community at large. Obviously, when you think about it, because that could increase or decrease the award depending on that person's income or wealth, but it kind of defeats the purpose of doing the more precise calculation to keep them whole. Does that help?
It does trigger that relationship to looking at actuarial charts to determine what someone would have made if they on a lost income claim.
Yeah.
I think that we'll be getting more into this later because I think
Yeah.
the question really goes to, are we talking about a method or an approach? If I'm
Mhm.
understanding where your
Yes.
question is going, Justice Hennessy. But perhaps we can continue on through the slides and
Yeah.
and come back to that, and there may be another opportunity for further questioning on that. Are you ready then to go to slide 6? Which is
Yes.
before us on the screen now.
Yeah. So a little bit of repetition because I've sort of introduced this, but so in the conventional approach, and I should say immediately before I get there, the approach that Mr. Hutchings took with net crown resource revenues is what we've looked at and considered to be a conventional approach, in the sense that he looks at the baseline scenario that happened, and that's where annuities were not augmented, and he compares it to a but-for scenario where the Crown had honored its treaty commitments and actually augmented the annuities. And he takes the difference between the two, and he does it on the basis of net Crown revenues in accordance with the decision of Justice Hennessy as amended by the Court of Appeal. So the first stage would be to do that factual or baseline scenario, and then the counterfactual. And when I say it's consistent, it's because he's used net Crown revenues in order to make that determination. And then we come later to the considerations of relative wealth and so on.
Could I just ask one thing? Alternate scenario, counterfactual, but for all refer to the same thing.
All the same.
Thank you.
A critical consideration in all cases, and especially this one, because this one is unusual because of the time period over which it extends. even accident victims who are injured early in childhood don't live for 170 years. So we all, and this is being debated and so on. But the choice of the appropriate, and it's another example of different terminology. You can choose whichever one. I often refer to discount rates because mostly these are events that have occurred, but the damage occurs in the future. You could use them if they've occurred in the past. You could talk about it as a multiplier, an escalator, or an interest rate. But no matter, they're all interchangeable. The idea is that you have to bring these differences that occur in a particular time period to present values because of the time value of money. And in some case, alternatives where you're looking and you're saying, what could the aggrieved party have done with that money in that period? Could they have invested it rather than consumed it? Could they invest in bonds? Could they invest in the equity and so on? None of those things I opine on. Dr. Mintz and I are not the experts that are speaking to those issues. So I'm not speaking to them in this testimony or in our report either. They're covered by other experts.
Can I ask you, you used a couple of possible terms. You made a distinction between what you typically call the discount rate when you're moving
Right.
backwards. And you said when you move forwards, you could use terms like multiplier or escalator. What about the term bring forward?
Yeah, bring forward is a good term actually, because it's sort of more of a basket and it's perhaps easier to understand.
Okay. I mentioned that because I think we have heard or will be hearing that term used in the evidence. And I wanted to make sure we were talking about the same thing. Are you ready then, Mr. O'Riordan, to move on to slide 7? As slide 7, I think, is really just the outline. Have you covered everything you wanted
Yeah,
to on the conventional
that's what I
approach?
meant. Another sort of reminder, a placeholder where we are. I'm finished as long as Justice Hennessy is finished. That's the thing that's most concerning, is that I don't want to move quickly and then we'll get into something that we wish I'd sort of explained better earlier on.
We'll
I
have
appreciate that.
we'll have the time to continue asking
Okay.
questions as they arise. So are you ready then to move on to the economic rents approach as compared with that conventional approach?
Yeah, so the economic rents approach is, it follows from the instructions that were given to Dr. Stiglitz and Mr. Hutchings. Their instructions were different than some of the other instructions that identified net Crown resource revenues. Instead, their instructions looked at the value of the territory's lands. So they're measuring something different. And the methodology that they've chosen to use in order to do that is economic rents. And so nothing wrong with that. It's just a very different path to get to an outcome. And a lot of what Dr. Mintz and I opined about and wrote about in our report really is our concern with that approach as under economic principles that are assumed and the kind of conclusion that you reach going in that direction.
Can I ask a question here? And this comes from all of the evidence so far, and it shows where I'm struggling.
Yep.
When you say they used a different approach, do I understand that it is an approach that might be used to look at what a country taxes? Is that when it's most commonly used?
That is when it's most commonly used.
And therefore, the criticism that comes is based on collecting taxes or something like that.
Yeah,
Okay, so if I have that right, that's
you absolutely have that right.
okay.
And that,
that's-
yeah.
So has it ever been used for an assessment of damages or compensation.
And we're coming to that.
Okay.
That's a very good segue into the next
Okay.
area of slides. But I like your question and your own answer, because there's nothing wrong with the concept of economic rents. And I absolutely want to, I think we state that in the report, but to be clear, our problem isn't whether they exist. Our problem is, in the real world, how to measure and account for them, and all of the difficulties that presents. And normally they are applied normally in the theory of optimal taxation. Because resources are in fixed supply, it's one of the few taxes that in principle and in models that we create with the assumptions that are imposed, there wouldn't be any distortion in the taxation, because normally there's distortion. And by that, I mean, especially, let's look at the corporate income tax. If you're providing incentives for one industry or one geography or whatever, you're in effect changing people's investment decisions. Everything in economics is in relative terms, not in absolute terms. That's an important thing to sort of get your head around, that there's a distortion because
People
you're-
try to avoid taxes.
well, they try to, they do try to avoid taxes, but they also try to take advantage of opportunities that taxes create. And if you're an investor with capital to invest, you're more inclined to invest in something based on the tax treatment of that capital. And there are examples that abound. Even in this last budget, there were a series of new investment tax credits that were announced, and they're refundable. So regardless of your tax position, regardless of whether you're actually in a cash tax position, you may not be, right? Because you've got deductions that aren't utilized fully. Regardless of that, you get the amount of the credit as opposed to a deduction. A credit goes straight to the tax line, where a deduction simply is deducted from your taxable income. So they're very strong encouragements, in this case for green technology and so on. But to your question, like about them distorting investment decisions, they clearly do. In relative terms, they make the cost of capital higher for everyone else. And the government can justify that if it's done to realize social objectives, obviously climate change and so on. But most economists, including Dr. Mintz and myself, and we've written a lot about tax reform, I have as well as Dr. Mintz has, we worry about distortionary taxes and the impact that has on investment decisions. And it also goes to the idea that the tax code is becoming so complicated that most ordinary people don't even understand it any longer. So it's not just a question of distorting investment decisions, it's ensuring compliance with the law. We all want to comply with the law.
Can I interrupt you there,
Yeah.
Mr. O'Riordan, just to bring us back to why we're talking about taxes? When we're trying to talk about economic rents and this theory of the plaintiffs that
Right.
focuses on economic rents, can you just remind us again how that gets us into talking about taxes?
Yeah, absolutely. And that is a key point. It's because in addition to measuring those economic rents, Dr. Stiglitz and Mr. Hutchings want 100% of those rents to be taxed. So they want those rents to be captured and distributed somehow between the government and the affected parties, the Anishinaabe. And
That wasn't my understanding.
Well, then it's
But-
good to have this conversation.
I thought your last sentence was correct.
Yeah.
So your first sentence was Stiglitz and Hutchings want 100% of those taxes or those rents to be taxed
Right.
and those taxes to be distributed.
Thereafter, as part of a compensation award.
As part of the compensation.
Yeah.
But I thought the evidence was, certainly from Professor Stiglitz, said, doesn't matter to him whether they want to, for policy reasons,
Mhm.
they want to encourage development of hydroelectricity, or they want to encourage settlement, or whatever the policy reasons may be.
Right.
There may be different tax treatment, but the but the consequences of an economic rents approach should still be distributed because it reflects value. Am I making
Yeah.
it? Have I properly understood that difference?
Well, I think the
What he
gap,
says.
the only missing gap is how do they capture the rents? And the only way to capture the rents is to tax them. That's the way those rents are
Is-
converted to government revenues.
Is capturing necessary
Yes,
in order to distribute?
yes.
Okay.
And
Okay, just- all
it'll
right,
become,
let me see if I'm gonna
Yeah,
try and catch up then.
yeah, yeah.
In my understanding.
Yeah.
And I realize that I'm asking you about somebody else's evidence, but it's what I'm getting is your
But-
understanding. of
yeah, it's my
their-
understanding, but I'm happy that you're doing that because that's my role. It is to assist the court. And my concern all through this had been that just watching it's so difficult to translate these concepts into understandable terms, you know? And if it takes longer to do that, it's time well spent.
For example, Mr. O'Riordan, you used the word a few times here, capturing
Yeah.
the rents. Would it be appropriate to also think of that as collecting the rents?
It would, in the sense that, like all taxes, and some of those examples I've used, and I'll use some examples later that I think that illustrate it better. But what you have to do is first, let's really go to first principles, okay? In Canada, we have voluntary compliance and self-assessment. So all of us, every year for our income taxes, we fill out a declaration and we submit it. And the Canada Revenue Agency looks at it and assesses it. They do it very quickly because they don't, you know, basically they don't review it initially, but you've self-assessed and they have assessed. Then they will look at it. If there are flags on it that raise attention, and they collect the money. Sorry, Ms. Evans, that's the collection part. The collection part has to take place, obviously. And in normal circumstances, it does fairly quickly. People remit their taxes by their due dates. And if they don't, then they're subject to additional interests or possibly penalties and so on. So there are collection issues that could be problematic. The Canada Revenue Agency has a whole collections branch that does nothing but try to collect due taxes and recover debt and so on. So depending on your circumstances, you know, obviously, but it's good to raise that because these are all things that have to happen in the ordinary course of events, including in making a compensation award based on the economic rents that could have and should have been taxed. A lot of what we're talking about, Dr. Mintz and myself both, are the practical difficulties for a tax authority to do that and the consequences of trying to do that. And that's why, as Dr. Mintz testified, you can't really find jurisdictions that do tax 100% of rents for lots of good practical reasons
That I think we'll get into. As
that we
move through.
will get into. But I don't want to move too quickly into some of those either, because it's sort of everything gets layered on top of the preceding point, right? So conceptually, and I'm sure that I shouldn't say that I'm sure that Dr. Stiglitz would agree. I guess that's going beyond my. But I mean I'm speaking objectively, neutrally as an economist, and this is as a tax administrator, and this is what happens. Taxes are voluntarily disclosed. Declared, the authority assesses, taxes are remitted, and then there's a whole appeal process that can follow after that. All taxpayers have the right to minimize their taxes. That's what's known as the Duke of Westminster case.
I'd like to bring that back to this case and Justice Hennessy's
Yeah.
question. Justice Hennessy, did you get your question answered?
Thank you.
Yeah, I
Yeah.
think we can move on to, I
it's-
mean, the point we were talking about is why are we talking about taxes when we're talking about economic rents? And I think
Yeah.
you've answered that question.
Well, and then the counterfactual, which we're going to be discussing in the economic rents counterfactual, it's presumed that those rents were collected. They were taxed and they were collected, and they were shared. So there are various steps as we go through here, but that's, that has to have taken place. And Dr. Mintz spoke a little bit about that. I'll speak a lot more about it. The practical difficulties in doing that.
So in these next slides, you go through the economic rents approach that Professor Stiglitz and Mr. Hutchings followed,
Yes,
and then you get into your criticisms.
exactly.
Did you want to finish explaining the approach of Professor Stiglitz and Hutchings?
I do. I
Okay,
do, because I think it's necessary, and I think it would be helpful to do that.
so I think that puts us on slide 9.
That's right. So what I've explained already is the conventional approach. So we have the factual and counterfactual, right? Using net Crown resource revenues, for which there's an historical record. We know what, I mean, there's lots of uncertainty around the data, but at least there are ledger entries throughout the period where you can actually look and see, these are the Crown revenues, these are the Crown expenses, the net is the time stream of income that should be, where annuities should have been shared and were not shared. And furthermore, that can be adjusted with consideration for the relative wealth, the wealth gap and so on. So that I think we all have a common understanding of, and there's no uncertainty around it. And what I want to do in slide 9 is to explain, to get to that same point using economic rents is fraught with a lot of difficulties. Some of them conceptual because of the assumptions that are imposed in the modeling of economic rents as opposed to the real world. And some of them simply because of measurement difficulties and having an exact definition and way to capture those economic rents that are owed to the land and resources as opposed to other factors of production. So the first step, you have to look at the total revenue that was collected from the sale of the land. That's not that difficult.
And
But-
resources extracted.
And yeah, I'm sorry. Yeah, I may occasionally assume when I say land that it's both, but I shouldn't do that.
No, that's fine, as long as we're all agreed that when you use that term, then you're talking about not just the actual land, but the resources on the land, the forests, the minerals.
And for the most part, I think I talk about the resources as opposed to the land. There are sometimes important distinctions that are worth raising, just in terms of the mobility of factors and output. Land doesn't move, or does move, and trees do move. And so that goes to the whole issue of what is a fixed supply, but that's down the road. So we've covered the first counterfactual, I think, fairly well, thanks in part to Justice Hennessy's question of me. Yeah, I mean, it does involve that they not only assessed those economic rents, but they actually collected them. So that has to take place first. Then there has to be a second counterfactual scenario layered on top of that. And this goes to the distribution question. And it's that the Crown and First Nations could have and should have entered into a joint venture agreement so that they could maximize and share those resources. So we don't have that in the conventional approach to determining damages, but we do have it in this approach. And this isn't imposed only by economic rents, it's imposed by their additional assumptions on how to distribute the proceeds. And then they layer on another assumption, which is this.
And now we're on slide 10.
Now we're on slide 10, thank you. Yeah, this final counterfactual has to be additionally modified so that the Anishinaabe receive at least 84% of the rents that the Crown would have received and collected. Had it done what they say it should have done under its economic rents methodology. And later we come to that 84% number, how we arrived at it. I'm just mentioning it here. So
When you
then
say how we-
finally,
How we arrived at it, you mean how Professor Stiglitz and Mr. Hutchings arrived at it?
yes, yeah. What I said, I meant in our
your
discussions, we're at that
presentation.
point in our discussions. Yeah, exactly. And then, of course, as with any compensation award, they have to take into consideration what actually was paid in the factual scenario. In our case, it's that $4 per capita unaugmented annuity that had been paid since, the 1870s. But we have to, and the whole time period, we have to deduct whatever was paid by the Crown in order to net out what should be the compensation. No one quibbles about that. So another placeholder slide, just to remind ourselves where we are. I've covered the first two approaches to compensation, and then I'll start talking in more detail. And I've talked a little bit about this already, but our concern with the limitations of the economic rents approach.
Good, and I see that we have a number of slides to go through on that, quite a number of slides
Yes,
to go through
yes,
on that. So
yes.
probably what we'll do is get started on it, and at some point, I'll slow you down so we can take a break.
Okay.
And can I ask you, please, sir, when you are talking about the limitations on the economic rent approach, whether you're talking about it as an approach to taxation or whether you're talking about it as an approach to compensation?
I would, with respect, I would say both. Because,
For every, so when you're identifying these different limitations,
yes,
you'll say it applies to both.
I-
All I was saying is when you answer the question
yes,
for Ms. Evans,
yes.
would you, if you can, distinguish where you say this limitation has an impact
Yes,
on
I,
taxation or
yeah.
compensation?
I will endeavor to do that. And if I haven't said it clearly enough, I know you'll come back and question me about it.
Or
but-
maybe
but
maybe you're asking me to assume it's for both, but
that's
when
part
I
of,
asked my first question
yeah,
on the use of the model, I asked about whether it's usually used for
yes,
taxation matters, whether it's in this case, it's
In
being
this
used for a compensation assessment. So if you see any distinction, I'll just ask you to identify it.
yeah, please do.
Thank you.
Part of both Dr. Mintz and I, well, any economist really, sometimes we leave things out where we shouldn't because it's too familiar and it's important.
And that's why I asked Mr. O'Riordan for you to remind us about the relationship between taxes and what we've been talking about here, which is economic rents. And
Yes,
so similarly, if you're able to, I'd like you to explain for the court why, in your view, taxation is related to compensation, such that if there is a limitation on the economic rents approach, it applies both to taxation and to the compensation in this case. Can you link the relationship between taxation and compensation one more time for us?
yeah, I'll take another run at that.
Thanks.
The two are inextricably linked because, and again, this sort of is part of the fundamental difficulty that Dr. Mintz and I had with the concept, and perhaps me even more so because of my experience in assessing and collecting and relieving taxes and so on.
And when you say in the concept, do you mean the concept put
Eco-
forward by,
The full taxation of economic rents
which is
so
the
there-
concept put forward by,
by Dr. Stiglitz and Mr. Hutchings. The first challenge is accurately measuring the rents. Okay, and we've talked somewhat about that, and I'll talk more about that. But that's the first challenge. But once you've measured them, as I said, no one has paid them. I mean, those rents have been taken by certain economic actors yet to be identified. In Dr. Stiglitz and Mr. Hutchings' world, they should have been captured by the Crown and then distributed
Through taxes?
through taxes. That's they are a notional concept, as we've said in our paper. And when I use that term, it's not pejorative. I don't mean that that's a bad thing. It's just a practical reality in the world that we know that they exist. And given some assumptions, they're actually very large. Given other assumptions, they're smaller. And we'll get into a discussion around what I mean by that. So, I mean, the first issue is conceptually, how do you measure them?
Them
what's
being
that
economic
quantum?
rents.
And then you have to capture them because they're gone. They're gone. Right?
And capturing is
It is
done
done by taxation,
by the government.
by the government.
What does that mean? They're gone.
What I mean is, we know back to first principles. So what Dr. Stiglitz and Mr. Hutchings have done is they've looked at the gross revenues that were collected from the resources, the returns, okay, before there's any taxation or anything, and no consideration about where all that money went. There was a lot of money that was raised through the land and resources and so on. And then from that, you back out the returns that should go to factors of production. And in a simple economic model, like they have assumed for use here, you have two factors. It's a two-factor model, two factors of production, labor and capital. The third is land, which again, when I say land in that context, I mean land and resources. And so they, in their world, in this theoretical model, they impose a condition that there's perfect competition in labor and capital markets. In other words, labor is homogeneous, is the term we would use. A manager is a manager is a manager, let's say, or a steel worker is a steel worker. They're all valued equally. They earn a competitive wage rate, and their opportunity cost, that's the term we would use in economics or in benefit cost analysis, is to look at their next best opportunity. And if there is a competitive market and there's full employment, then they would alternatively be employed in a different industry or in a different company at the same prevailing wage rate. And the same with capital. If you remove considerations around risk and so on, capital would have what we would call a normal rate of return. So it could earn a return in this business, in this sector of, let's say, 5%. And the opportunity cost of capital is 5% because it would earn the same rate of return in a different industry. So that's the competitive assumptions that are built into the model that allow us to isolate economic rent and say that rent should all go to the fixed production factor, which is land or resources. I mean, it's earned by them. Why? Because, there would be nothing that would happen with that land and resources but for their existence. If there was, okay.
Okay, I'm just going to slow you down.
Yeah.
Because this is a place where I've also been stuck.
Yeah.
So this thing that we've heard about called, what do you call the normal rate of return?
Right.
Is it possible that Professor Mintz called that a normal profit?
Yes.
Okay. So the surplus profit?
Or
that he
supernormal profits or yeah.
Surplus, or I don't know what else you called it, surplus, I think, profit. You
Excess.
just, what?
Excess
Excess.
is another word.
Excess,
Yeah.
was another word he used for it. So you say, or you're explaining that is what goes, that is now called a part of the economic rents, that goes to the value of the land.
The excess in Dr. Stiglitz and Mr. Hutchings' opinion, anything over the normal profit
Yes.
is economic rent, and it should be attributed to the fixed factor of production.
And the normal is
The
this rate of
competitive
return,
return,
the
yeah.
competitive
Yeah.
return that you could get somewhere else.
Yes. Yes.
So you say to Falconbridge now,
Yeah.
Glencore, or when you're looking at, if you were imposing the economic rent approach to taxation, you would say to Glencore, well, you can get 5%,
And you're onto it
okay?
because,
Just let me.
Yeah, yeah, yeah.
Let's see if I got it.
Yeah.
You can get 5% profit.
right,
That's normal. That's what you can get. And you'll be taxed on it
Yeah.
in the normal course. And what your balance sheet shows as more profit, you're also going to be taxed on that
Yeah.
differently.
yeah, well, there are different ways to tax it.
I'm just trying to figure out that
but
go
you- but-
back to it goes back to the value of the land, but what, and this other statement of yours, it's lost. What actually happens to if their profit this year is 7% instead of 5%?
That's a good, okay, that's a good example. So if their profit had been 7% instead of 5% in this model,
Mhm.
then that would be viewed as an excess profit.
Mhm.
And it would be an indication that they've actually captured and taken economic rent.
Mhm.
And the view would be from Dr. Stiglitz and Dr. Hutchins, or Mr. Hutchins, that that would be inappropriate because the Crown should have stepped in and captured that rent.
100. Oh, and that's the 100%.
That's the 100%. Well, it's part of the rent. There may be other, there will be rent that is realized by other parties, taken by other parties. And as I'll talk about later, in my opinion, some of that rent really does belong to them, but not all of it always.
Okay, well,
When
let's
you
talk to the
say-
pure situation. The
Yeah, the
pure
pure-
situation is that over 5% is
Yeah.
the
Is economic rent.
is economic rent. And you say, as Stiglitz and Hutchings say, that full 2% should be captured, i.e. collected,
Yes,
and then put in a column where that is measured for the purpose of distribution and augmentation.
yes.
I'd
I'm
like
just
to,
going to catch up unless
I'd
I'm
like
wrong.
to ask a question now. Are you ready?
Does it take
It-
away from that?
No, it follows.
Okay, let me just get that down
Yeah, yeah,
because,
yeah, yeah.
okay, thank you. Go ahead.
I want to follow up on that same
Can
example.
can I,
Can I ask? a
okay,
question?
okay.
I want to follow up on that same example where the normal profit to meet the opportunity costs of the labor and capital is 5%. But here, the company has earned 7%. So there's this excess of 2% that we're saying is economic rent. And you're going to describe for us a variety of reasons why measuring that 2% is very difficult. But you're also, can you tell me that 2% of economic rent, does it necessarily mean that that's the value of the resource? Or are there other factors that could be taking up part of that economic rent or responsible for that economic rent?
Well, there are other factors that could be responsible, and I'm not sure, Ms. Evans, if I get into that a little bit later as well, but I can
That's
start to address it. But yeah, that is part of the complexity and the difficulty with the economic rents approach. And what I had wanted to add as well, just before that question, following on Justice Hennessy's remarks and conclusions and so on, back to that 5%. One of the reasons that this is complicated stuff is when Dr. Mintz testified, he explained well that you've got to factor in risk. And so I haven't factored in risk because in the simple, just conceptually to understand it, it's better to leave that off the table and just stay with the assumptions imposed in the model, which is capital is mobile. It's all, it earns a competitive return.
And these are
same as labor,
assumptions imposed
of
in what
Dr.
model?
Stiglitz and Mr. Hutchings in their model. But in the real world, and in their model too. I mean, there can be more sophisticated models. I do not mean to undermine or underplay the approaches of Dr. Stiglitz and Mr. Hutchings. My conclusion is that they're putting us on a wrong path, and it's not an easy path to follow for purposes of determining compensation. I think the net crown resource revenue path is a simpler one to follow, and it should result in a just conclusion. At the end of the day, that's what we all want, is to arrive at a compensation number that is not just satisfactory, but satisfying, that everybody gets a sense that, you know, regardless of which party you are, justice has been served. And the only thing I wanted to add is about those risk adjusted rates of return that Dr. Mintz testified about. That's an additional example that, you know, I would say, in addition to what Justice Hennessy has just absorbed, that has to be layered on as well in the real world, because I don't touch on that really in mine. My remarks relate more to rents and measuring and capturing rents, where Dr. Mintz's remarks were more in terms of how to measure what resource revenue should be included and how would you measure those, both on the revenue and the expense side. And that's where risk adjusted rates of return come into play compared to the ones that were used by Dr. Hutchings and Dr. Stiglitz and Mr. Hutchings.
So I think it might be a good time for a break.
Yeah.
I know a lot of these concepts are complicated. So why don't we take a break if that's works for the court? And when we come back, we can get into your slides on where you explain these limitations.
Very good. Let's take the break.
Yeah, okay.
All right.
15. And I'm going to stay here.
We've got a recess for 15 minutes.
Chelsea, come and help me.
Sure.
Okay.
This court will recess until 1 o'clock. This court will now resume. You may be seated.
So my apologies once again. I've got a replaced laptop and we'll
Move ahead.
move ahead.
All right.
Thank you.
Mr. O'Riordan, to start, I want to go back to a question that Justice Hennessy asked earlier, and I'm not quite sure it got answered. And it has to do with, where do the economic rents go if the government doesn't tax them and take them? So using the example that we talked about earlier of a mine that earns a normal profit of 5%, which is what is required to pay the opportunity costs of their capital, their labor. If that mine made 7%, we talked about there being 2% excess, which would be viewed as the economic rent. So can you explain then, if that economic rent is not taxed by the government, where does it go?
Yeah, that's a good question, and the answer is it would stay with the mining company. In fact, there could be additional economic rent above and beyond the 2% that we had discussed, that difference, but it also would simply stay with the mining company, whatever amount that is. If it was not taken by the government in the form of taxation, it would stay with the company.
So we were going to, you were going to lead us through what you've called the limitations of the economic rents approach. And I think we left off at slide 12. Do you want to start going through that?
Yes, thanks. That's exactly where we left off. And in our estimation and in our report and in my testimony today, I want to cover 3 different reasons why Dr. Mintz and I felt that it wasn't the appropriate framework for determining compensation. The first of our reasons, and this is in conversation between Dr. Mintz and myself, the economists, I'll mention quickly and then pass on, and that is just our reading of the of Justice Hennessy's decision and the Ontario Superior, the Ontario Court of Appeals decision, where they were directly referring to net Crown resource revenues from the territory in several locations, as opposed to the wealth of the territories. And so for us, we took that as an indicator that that is the way, that is the path forward to determine what the compensation should be. But as I note in my second bullet, before I'm even objected to, that that's above and beyond our competence. We're simply in, we're just taking a textual reading of the decisions, and we felt that that supported the idea that we should stay on this track with net Crown resource revenues, as opposed to starting a new track with economic rents. So we set that aside. I don't have any, I don't place any weight on that, and I don't expect anyone else would either. If that's fair.
You don't place any weight on the fact that that's how you chose to do it.
Yes.
Okay.
I put all the weight on the second two reasons that I'll go through, because that is where our competency lies.
Because the first issue is really a legal issue. Is that what you're getting at?
Exactly, yeah. A question of interpretation.
All right, then. So going on to your second and third reasons, then I see we're on slide 13.
Yes, so on slide 13, I simply summarize the two reasons, and I'll go into more detail in the subsequent slides about what I mean by each of them. The first one being that if it were the case that 100% of all rents were taxed, we believe that this would have meant the pace of resource development would have been slower. And to the extent that that would happen, it also means that it would be inappropriate to rely upon the historical data that is there to calculate those economic rents. And as I said, I'll get into more detail about what I mean by that a little bit later. But that is the first point. And the second is that even if you could overcome these difficulties, which we don't believe is possible, the actual calculation of those rents has so many measurement problems and so many assumptions that it to our way of thinking, it eliminates that framework, the use of that framework as a reliable framework to calculate compensation. And we put a lot of weight on the idea that compensation, as I said earlier, when it's determined, our hope would be that everyone would see that as the appropriate quantum and a just outcome for the wrong, for the failure of the Crown to augment the annuities.
Can I just see if I've got this? Your last reason is that the calculation of those rents is based on so many assumptions. It makes the method less reliable.
Yes. And I think there'll be some, if I don't mention some examples, I'll take the opportunity to do that now. And I think as we're getting into Hugh Green's report, or Hugh Grant's report, it's probably a place, because if you look at the conclusions there were several different studies where the variance.
Can we maybe backtrack to talk, what
Sure.
study are you talking about? Are you ready
Well,
to
let's-
take us maybe
yeah,
to the
let's-
next slide?
Yes, I am.
Yeah, so I think now we're on slide 14,
Yes, that's right.
and maybe you can explain for us what study you're talking about.
Yeah, that's a better way to start too. I appreciate that, Ms. Evans. So at one point in their report, Dr. Stiglitz and Mr. Hutchings assert that the use of economic rents to value lands is not a novel idea. And they cite a report that was written by Hugh Grant, who at that time was an associate professor of economics at the University of Winnipeg. And this was part of a suite of reports and studies that was commissioned by the Royal Commission on Aboriginal Peoples, as we called them, in 1991. So it wasn't used as a method to determine compensation, but they are quite correct to say that it had been used to estimate the value of land and resources to Indigenous peoples. So when it was cited, I read the report because I found that interesting. And what I found also interesting is in an appendix to his report, Professor Grant laid out what he considered to be criticisms of some of the analysis of benefits received and costs foregone that were contained in another study. So he's got his study and he's critiquing another study. So I know it's a little bit confusing, but the point is his criticisms resonated with me because they were exactly the types of criticisms that I felt would be applicable in this context. So he was not talking about a context where there was a compensation award to be determined. He was simply talking about valuing Indigenous lands in general. So a step a little bit behind this. And if we could go to the next slide.
I think before we do on slide 14, I'm just
Mhm.
hoping that you might get to it. But you say here that Grant's definition of economic rent is not identical to the definition employed by Dr. Stiglitz and Mr. Hutchings. Will you be getting into that?
Yes, I am. That bullet I put is sort of a segue to the next slide.
All right.
And it is the first bullet in the following slide.
So now we're
Um,
on slide 15.
Yes. So Grant made it clear, a number of points, among them he made clear was when you're measuring economic rents as a way of determining the value of resources, you shouldn't just be looking at private costs and benefits to the manager of the resources. You should take a broader view than that. And
Sorry, when you use the word manager, could we also call them like the private sector owners?
yes,
Okay.
yeah.
When measuring economic rents as a way of,
Yeah, and it could be a public sector manager as well,
Oh.
but I take your point. I in our context and most, it would probably be a private company that was exploiting the resources, extracting and refining or harvesting or whatever it might be, depending on the resource, or building the hydroelectric dam. And I mean, in that case, it would be more typically a public sector entity, a crown corporation or something. But the point is the same, that when resource rents are measured, they should be broader. The first quote is, and I think it's worth repeating there, resource rents are no panacea for economic development. Exploitation of a non-renewable resource base is by definition not the basis for a sustainable economy. And part of the reason that resonated with me was in the other studies that have been commissioned in this context here for us, looking at Anishinaabe history and culture and values and so on, that struck me as the way the Anishinaabe would look at this as well, that they have a stewardship of the resources. It's not to maximize the returns from the resources like a private sector owner manager might decide to do. And I'm not saying that they all would decide to do that, but typically they do. They don't take into consideration social costs and
Who's they?
benefits. The private sector owner
Ah.
or any owner of the resources.
Thank you.
Thank you.
but private sector owners are not what?
You were saying typically they don't take into account.
Typically, yeah, they would only take into account their private costs as opposed to social costs. And we have a little bracket around this so I could talk about what I mean by social costs. And this goes to the area of benefit cost analysis that I mentioned earlier. When we set out guidance to federal departments how to conduct benefit cost analyses, we always insist that they look at social costs. And what that means, for example, in the case of a mine, to the extent that the mine might cause pollution, or it might cause some degradation of the environment, whether it's air or water or whatever, then those costs, which are not private costs, they're not borne by the company, they're social costs, they should be included in the calculation of economic rents. And there should be sufficient tax revenue allocated to their remediation that those aren't taken as revenues by the government or whomever. In this context, I think Hugh Grant's point is that the Anishinaabe would want that portion of economic rents saved, preserved, and allocated towards the protection, preservation, conservation, whatever word, of the natural resource and the land and territory.
As opposed to being collected by the government in
Exactly.
taxes.
Exactly.
Sorry,
So-
as opposed to being,
Collected by the government in taxes.
That's right. What I'm getting at again is what Dr. Stiglitz and Mr. Hutchings are saying is that part of the gross revenues, that is the residual after you take out the competitive returns to labor and capital, which we all agree is economic rent, part of that should not be taken either by the government or by the Anishinaabe in our case, but should be taken in order to remediate the social costs that are caused by the extraction of the resources.
okay, I just want to keep going with that idea.
Yeah,
The economic rent should not be taken by the government or the Anishinaabe.
right.
It should be, then you
It
use
should
the
be,
word taken.
when I,
or
yeah,
Allocated.
I use the word, yeah, allocated is a good word.
To a budget line for remediation.
Yes,
But in fact, if I have this right,
yeah,
there's no invisible remediation. I don't know, God or something that needs those monies. In the case where the government is the taxing entity and generally thought to be responsible for the environment, the government would take those costs. And instead of putting those costs in some budget line over here, we don't know who runs it.
yeah,
They would put in a budget line for remediation.
yes,
And and when you use the words should not be taken, it could as easily be taken by the Anishinaabe who would be responsible for remediation.
and they may or may not choose to do any remediation. That's their decision to do. But what,
Well, just to say it,
Yeah.
what you're saying is when you use the word should not be taken by, I'm not sure what that means. Or it should be attributed to when when you give advice,
yes,
you say, take this benefit cost consideration into account. And then you come up with should not be taken by, but what I think what you're really saying is should be allocated to social costs.
yes,
Okay,
to remediation of the of the damages, which is the social cost.
so your advice is in the positive, not in the negative. It's not that it should not be taken by certain entities, but no matter who takes it, it should go to the social cost.
That's a good way to put it too.
Okay,
Yeah.
okay, got it. Sorry, but
I mean,
that's-
an example would be the carbon tax. It's not a perfect example because I'll just explain. The carbon tax is imposed because of the pollution that carbon costs. And so one way of changing people's behavior is to tax carbon. We pay it at the gas pumps, right? The idea there isn't that they're doing remediation of the pollution, the air pollution that's caused by that. It's to discourage additional consumption. And the way this scheme works, the government taxes it, but then refunds it as well. And a lot of people don't get the logic of that, but there is a logic to that. As I said, we economists think in terms of relative prices. So what that does is it increases the relative cost of fuel compared to anything else in your basket of consumption. And the fact that they reimburse it to people is a choice of the government. They don't have to do that, but they've chosen to do that in order to make that bitter pill a little easier to swallow. And it's not perfect in the sense that some of that income that's returned to them, obviously people will use to buy more of that bad product, but not much of it, not much of it. Whenever relative prices change that way, we economists talk about an income effect and a substitution effect. And in this case, the substitution effect of that scheme is to reduce the consumption of carbon.
Okay.
The income effect is compensated by the lump sum payment back. And I apologize if that's sort of going off track. I'm just trying to illustrate the idea of social benefits, social costs, and how taxes are used for that purpose. And Hugh Grant's point was simple. It's not taken in, it should be taken into account always in the calculation of economic rent. And Dr. Stiglitz and Mr. Hutchins have not done that. And I think Hugh Grant's approach is a more appropriate approach, and I think it's closer to the Anishinaabeg values as well. The idea of stewardship of the resources, conservation, the good life, but not at any price.
Well, what do you mean they haven't taken it into consideration? Because
Well,
there's no consideration of what the Anishinaabe do with the money once they get it.
no, that's right.
So how does
So-
he know? How do you say they're not considering that they're going to spend money on the environment?
And they could. I mean, I
Can I
grant.
interrupt, say, who's they?
I keep saying they don't.
Professor Stiglitz and Mr. Hutchins?
Yes, it is.
Okay.
Yeah. They don't take explicit account of it. And I think they should have done that.
Of
Of
environmental.
the social costs. Yes, yes.
So
In
then-
other words, back to first principles. Their definition of economic rent is the gross revenues less the competitive returns to the other factors of production. Everything else that's on the table is economic rent, and it should be taxed at 100%, and it should be allocated according to their various proposals for sharing. I would say a better approach would be to explicitly account for social costs and allocate that portion of those economic rent revenues and specifically put them in the line item that you're referring to and take that action so that in effect, neither the government nor the Anishinaabe get that portion of economic rent. And Grant's idea, it's only applicable in some circumstances. It wouldn't always be applicable, but certainly in some where we know that there is environmental degradation that's caused by resource development. There's no question about that. That would be his approach. And I think he's guided by Anishinaabe values when he says that that's the way to do it, as opposed to private developers who would not do that unless the government forced them to do that. And the government could force them to do that. But to that extent, their cost base is just increased. And so that's not part of economic rent anymore that would be shared because it's taken
Right. So that's a
by
third way of
remediation.
doing it.
Yeah,
The government could keep it and be responsible for environmental remediation.
yes,
Could give it to the Anishinaabe
yeah,
and they could take responsibility for environmental remediation. Or you could say, you could pass by law or regulation that the owners, operators of the
Yeah.
resource extraction companies have these obligations. They have to replant the trees, they have to remediate the mine sites. And so it becomes a cost.
yeah, perfect example. Because that isn't, regulation is always an alternative.
But just say those are three different ways
Yeah.
to achieve the same result.
Yes,
Okay.
I wonder if, I hope I'm not going to muddy the waters, but is it possible to think of it like when you talk about, when Professor Stiglitz and Hutchings showed us, for example, that you've got your revenues and some of it is going to pay off capital and some of it's going to pay off labor and, other inputs. And then they have economic rent at the top. And it sounds to me like what you're suggesting is maybe there should be another layer that's divide that economic rent with another layer that is the social costs, paying
Yeah.
back the social costs. So in a way, the point that you're making about taking, that Grant is making, about when you look at that economic rent, think about a portion of it really should be invested back into the social aspects. And that actually shrinks the economic rent that is now available for the government to tax and share with the Anishinaabe.
that is exactly what I'm trying to say. And you may have said it better just there.
That may have been a leading question, but that's-
But you've forgiven all of my leading questions up till now.
Indeed. Look, I'm not objecting because this is an area where the experts are going back and forth. And
Thank you.
I think it's just fine. My concern, if there is one, is that I don't know if some of this stuff is actually in the reports. And if it's not, we would have to consider whether under all the circumstances. That's the
Okay.
way I would deal with it.
Yeah, and
I've been wondering that today.
I am about whether it's in the report or whether my leading question.
No, about whether it's in the report, because I know I take responsibility for taking us down a certain road.
I know I do acknowledge that it was a leading question, and I'm trying to refrain from leading questions. It is complicated in this the economic explanation. My understanding, though, Mr. O'Riordan, can you take us back to, I know here you cite that in your report, you did deal with, in your SIR reply as well, I believe,
Yeah.
you dealt with the grant report and the fact that you and Professor Stiglitz and Mr. Hutchings take different views of that grant report. So maybe what we need to do is finish going through slide 15, because here I see that you've actually cited your report for paragraph 112 here. So can you bring us back to how you deal with this in your report? Maybe what we should do is actually look at the report.
Are you taking me to the
Well,
main report?
I
main report?
wonder whether that would be helpful. My friends
Yeah.
think it would be helpful to go to paragraph 112 of the original report written by Professor Mintz and Mr. O'Riordan, because that is the paragraph that is cited in Mr. O'Riordan's slide 15, where he talks about explaining, and the grant report, again, was, you're responding here to Professor Stiglitz and Mr. Hutchings, is that right?
That's right.
Sorry, paragraph 112?
Yes.
Thank you.
Perhaps, Mr. O'Riordan, you can take us through the point you make on your slide 15. I think we're at your second bullet point.
Yes.
And then perhaps in order to ground it, and you can take us back to your paragraph 112 and show us how it fits in.
Okay, I'm just sort of hesitating because I'm in my second bullet, I'm really paraphrasing and not paraphrasing, I guess condensing the longer quotations that I've included in paragraph 112 of the report in order to get that concept around. The concept is fairly simple. There's a lot of detail here, but what Grant is pointing out is that the Anishinaabe may not have developed the resources in the same manner as what factually occurred for a variety of reasons. And therefore, that factual scenario would change because of the pace of resource development. I don't know if I can make it any.
So there's an assumption, you say they might not have developed them in the same way.
Right.
And one assumption is the pace would have been slow.
Yes.
Not for sure it would have been, but one assumption is the pace would have been slower.
Yeah, I mean, I would go a little farther than that in that when he says the pace would have been different, he really thinks it would have been slower for a variety of reasons that he gets into. And I might have continued to quote that in the next slide. I'm sorry, my memory.
I was thinking we probably are on slide 16 now.
The monitor's on 15.
Yeah, we'll switch to slide 16.
Okay. Oh, okay, it's up.
And again, we're talking, this grant report is a report that was referred to by Professor Stiglitz and Mr. Hutchings, and you have read the report and are responding to it. Is that right?
That is correct, yeah.
So can you
it-
take us through then this slide 16?
So further to my point that the pace of resource development would have been different for a variety of reasons. One of the reasons that the grant states is questioning whether capital markets would have been prepared to lend on the same financial terms with the Anishinaabe as they would with the Crown or with a private resource developer. And that just goes to the question of risk and the cost of capital or any kind of risk premium that they may have wished to have. In other words, access to capital markets might have been more limited, and the terms under which capital was acquired and utilized might have been more strict, higher cost, in other words. I also said, I mean, not to put it all in the negative. I mean, they may have made decisions on their own that too quick a pace of resource development would be inappropriate because it would possibly cause unintended side effects, such as pollution or, disturbance of land that they wish to enjoy in a more traditional way. I mean, Grant doesn't go through all of those reasons, but his point is that's the direction. It wouldn't hasten resource development. It would slow it down. And then he goes on to say that, and that's why I thought it was a quote worth stating. Any model based on a comparison of a counterfactual and actual state of affairs is vulnerable to criticisms of this nature. And there is an obligation to present the most plausible alternative scenario and emphasize the limitations and potential biases in the modeling process. And that's really what's driving Dr. Mintz and I in our assessment of the different paths to determining compensation and why we think net crown resource revenues is firmer territory to mine, if I can use that expression, in terms of the reliability of the results. And as I've said before, we recognize that, especially in the case of this Superior Treaty, it may present some problems if the net present value of that stream of net resource revenues is not viewed as sufficient for the purpose of calculating compensation. It can be adjusted, and the Court of Appeal has actually suggested a method of doing that, which is to do the comparisons of net wealth and so on, and make it an adjustment that seems appropriate. And I do talk about that later, and I don't have, Dr. Mintz and I didn't, we offered some suggestions around those things without the same criticisms that we would have of the economic rents approach. You could criticize that as being arbitrary, but we're not doing that. It is arbitrary, but it's not as arbitrary as trying to calculate all these economic rents and come up with a determination which we think could be bounded easily as sort of a worst case, best case scenario, what the value of those rents are. It's a much tighter bound around net crown resource revenues, more reliable and fair in that sense. I should not use the word fair. In taxation, we avoid that term as well. But I mean, one that's viewed as just. The arbitrary nature of making an adjustment after that is less than ideal.
And just
But
what adjustment are you referring to?
the adjustment that you would do to take into consideration the wealth and income gap that clearly exists.
You say it will be arbitrary, that adjustment will be arbitrary, but
It could be useful because it would allow you to arrive at an appropriate level of compensation. If it turns out that net crown resource revenues are felt to be an insufficient amount of compensation for the failure to have honored the treaty, then it's kind of a lever that can be used to elevate that compensation. I say elevate because clearly there's only one directional way to go. We know that there is a significant wealth and income gap. So if it's relevant, then it will raise the level of compensation to what is seen to be appropriate. And I do have comments around that later.
When you
So
discuss the.
yeah,
income gap, we'll get to that.
I shouldn't get too deep into that. It's just,
Can we then pick up on your criticisms of the economic rents approach? I think we're now on slide 17. You finished going through the grant report and
yes.
Can you take us through slide 17 then?
Well, so back to the idea of economic rents and taxing them at 100%. Over and above, and for different reasons than Grant has identified, that would slow the pace of economic development. That approach would certainly have slowed the pace of economic development and potentially reduce the economic rent that could be realized. Because the pace of development is slower, gross revenues are smaller, and the portion of the pie that is left, the residual economic rent, would shrink as well in any given period of time. And I'll say more about that later in subsequent slides. But one reason is because with that degree of increased taxation, the private companies would want higher risk-adjusted returns. And the joint venture relationship is really where that comes in. I mean, if they were on their own,
Who's they?
the private companies developing the resources, if there was no joint venture relationship, their access to capital markets would probably be stronger. The cost of capital would probably be less. Under the joint venture relationship, they may have to pay a premium, a risk-adjusted premium. And they also then are getting into a situation where some of the capital, some of the labor could be bid away to other projects because the return on capital and the wages earned could be higher in those alternative employments, the opportunity cost, as I said earlier.
And I'm sorry, I have another question. I don't have it before me and it's not the front of my mind, but when Stiglitz and Hutchings spoke of a joint venture arrangement.
Yeah.
Was it an actual joint venture relationship they were supposing, i.e. joint management? Or were they saying the sharing should be akin to a joint venture and the revenue sharing should be akin to a joint venture? I don't recall reference to joint venture management.
So we will, that's a good question and we will come to it. They're really saying both. They're slightly different things. First of all,
Okay, it's okay if you're gonna
yeah,
get
we'll-
to it,
we'll
but I
c-
just want to say, but
Yeah.
your then next point is presumes it's joint venture management because your comment
mhm,
about access to capital markets
yes,
is based on an assumption of joint venture management as opposed to, as I say, what I understood, a revenue sharing model that was akin to a joint venture. I might be wrong, but, and if that's right, then this issue
would,
is a non-starter.
would go
It's
away.
not relevant.
Yeah.
Got it.
Yeah.
Okay,
Yeah.
but you say that Stiglitz and Hutchings say both.
Yes, in the counterfactual, they use the word joint venture or shared risk interchangeably. And I will speak to that more later
Okay,
in subsequent slides. But then the idea of the sharing is yet another concept that we'll come to after that. So both of those things are in their report.
thank you.
Are we then at slide 18?
Yeah, I'm just waiting for it
No,
to
no, go ahead.
Okay,
come up.
slide 18.
Sorry. Okay, so, yeah, it's up now. I
think
can
it's
see it.
tiny.
Oh.
Oh, here we go. Mhm.
Oh, it's bigger. So my first bullet, I'm going to take some time with your indulgence to go through what I mean by this because I think it's important and it hasn't been fully developed yet. And it's the whole idea of transfer pricing, which Mr. Hutchings spoke to and Dr. Mintz spoke to. But once again, I want to speak to it in a little bit more detail from first principles and give you an example of what I'm talking about, because I think it would be helpful.
Go
So
ahead.
most of the resource companies that are relevant here, the natural resource mining companies or whatever, are multinational firms. They're large companies with good access to capital markets, with good labor forces, with a lot of capacity to do what they're doing. Like the Falconbridge example when I was here before, as I said, one of the things that's impressive is the technology that's used to be able to access or effectively, efficiently, that wouldn't be accessible if they didn't have specialized labor and innovation in terms of mining technology. The reason I mentioned multinational firms is because that is where transfer pricing comes in. So I want to go step by step and just explain what Dr. Mintz and Mr. Hutchings were getting at. They talked about non-arm's length transactions.
Perhaps
okay?
Stiglitz and Hutchings?
I don't.
Or when,
think so.
it was both Professor Mintz
Yeah,
in
I'm
his
talk-
evidence.
Yes,
Okay,
yes,
thank you.
exactly. Yeah. So they're talking about transactions between non-arm's length parties. And where most of this happens actually is cross-border transactions. And so companies that have a presence in more than one jurisdiction have the necessity to have transfer pricing in order to do their accounting and do their tax, their tax accounting. And in particular, where they have subsidiaries that are located in a different location and so on. Where they're transacting with non-arm's length party, it's not an issue because we have market prices that, that are clear and we understand those. The bilateral tax treaties that I mentioned are there for a reason. The primary reason is to avoid double taxation. So how does double taxation occur? It occurs when people in two different tax authorities, say Canada and the United States, well, say Canada and Switzerland, because I'll get to that a little bit later, Canada and Switzerland. That company has economic presence in both of those jurisdictions. And there's a mining operation in Canada and subsidiaries in Switzerland. The subsidiary could be for,
Mr. O'Riordan, I just want to interrupt you there to
Yeah.
have you remind us what is the relevance of this transfer pricing example here?
the relevance is I'm trying to illustrate how tax planning will reduce the base of taxation and how profits will be shifted out of a jurisdiction. Because if you get into two different jurisdictions that have substantially different rates of taxation, and that is the case for Canada and Switzerland. Canada is a high tax jurisdiction. Switzerland is a low tax jurisdiction. And companies have an incentive to take advantage of those different tax rates to maximize their post-tax profits. And the vehicle they use to do that is partly law and accounting, but it's based on transfer pricing. So double taxation happens if a lot of revenue is shifted to the low tax jurisdiction and is taxed there. The tax authority in the high tax jurisdiction will come in and audit and assess, and they will assess that revenue as if it stayed in the home jurisdiction. So you have two different assessments on the same revenue.
And can you just, I'd like to move on to this point because I think you've got some other points and I'm concerned about time. Can you just wrap up for us then why this transfer pricing issue is relevant here?
Well, it's relevant because if you tried to tax all of the economic rent at a very high rate of tax, the company will do tax planning in order to minimize their liability for tax.
And what is the effect of that then on the availability of economic rent for the government to tax?
It's drained away. It's gone.
Thank you.
It's gone to another country. another jurisdiction. And
It
it
drains away profit.
drains away profit, and that drains away tax.
So I
Well,
think we're
tax,
now,
but but we don't care about tax here. It drains away profit, which could be shared. It drains away surplus profit.
Yeah, the only reason I come back to this all the time, the only reason that I mention tax is the vehicle by which that economic rent is captured and distributed,
Okay,
right? Yeah.
so I think we're on your second point then on slide 18. Can you take us through that?
So the second point, I'm back to identifying those factors of production. So in Stiglitz and Hutchins' model, the competitive model, land and resources are a fixed factor, capital and labor are mobile, and they're priced at competitive rates. So back to what I'd said before, that means there's a normal rate of return for capital, and there's the normal income earned by workers. And everything over and above that is economic rent. And it's assumed that that economic rent is generated, is created by the land and resources.
It's assumed by whom?
Well, I would assume that as well in that stylized model, the perfectly competitive market that Dr. Stiglitz and Mr. Hutchins use. Any of us as economists would
as economists.
totally agree on that. No question about that. So our only disagreement is when you try to transfer those simple assumptions into the real world, then they don't hold. And
that
the
take us-
example that I'm using in the second bullet is to sort of set the stage for commentary around the idea that all factors of production are the same, all managers are the same, all capital is the same. And we would say that that isn't the case. And I think Dr. Mintz commented on this, and the illustration was around hockey players, Wayne Gretzky compared to another member of the team. You can see that the Gretzky salary is significantly higher than his teammates. And the reason for that is because, like land and resources, he's sort of a fixed factor of supply. There are only so many Wayne Gretzkys, and there will be bidding at a high level to get his talent and skills in your team. And that is all rent. That's economic rent that he has earned as a factor of production. He's labor, but he's earned that return. And Dr. Mintz used that example because it's somewhat simpler than the idea of managerial rents. But I think he did mention Elon Musk as another example, where there are very few of them, and they earn economic rents. And by the same token, if you look at capital, or let's call it the combination of capital and labor, where I'm talking in this bullet about innovation.
Are we now on slide 19? Are you on slide?
We're still on 19.
But we just moved to 19. You're okay with that?
Oh, I apologize.
Okay.
I was on, yeah, I saw
Okay, good.
19 for some
We-
time.
This is the first
sometime
time I'm mentioning that it's slide 19.
No,
Just
I
wanna make sure we're all on
apologize.
the
I
same
thought
page.
yeah, I can see it on my monitor, so I'm just assuming everybody's watching that. I'm sorry. That is the first bullet in 19. And I was starting to say, in addition to those managerial rents, which are real and exist, just like the economic rents that accrue to the land, there are economic rents that accrue to innovation. And some of them are actually identified. Unlike most rents, they are identified because we have patent laws, trademarks, and so on. So those there's legal protection around them where other people can't use them. And the returns to that intellectual property, or IP as we call it, is rent. And it's another illustration of the difficulty of capturing all of this by taxation. Intellectual property, patents, for example, are a perfect example. They accrue in any industry. They're probably most prevalent, let's say, in the pharmaceutical sector. And that's where there are a lot of transfer pricing cases involving pharmaceutical companies who've taken their intellectual property and exported it to a low tax jurisdiction. And so the reason is because the low tax jurisdiction provides preferable tax treatment. It argues that some countries, including Canada, should take special consideration and have lower rates of tax for intellectual property rather than higher rates of tax. And the reason is because they would actually realize more revenue. If the tax rate were lower, there'd be less incentive to shift the profits than if the tax rate is higher. It's the high tax rate that encourages companies to export their intellectual property.
I think
Some
we're-
countries, like the United Kingdom, has what they call a patent box. So if companies qualify for that, they can actually qualify for a lower tax rate in return for keeping their patent in the United Kingdom, as opposed to letting it slip away. It's an
So-
yeah.
Can you just bring us back, Mr. O'Riordan, as to, you're talking about patents in the context of other factors of production or
I'm
what?
talking about them to illustrate the point that there are other economic rents that accrue to factors of production other than land and natural resources.
And that's your second bullet point on this slide 19.
That's right, yes.
Can you
So,
continue taking us through that.
yeah,
slide
so
then?
in conclusion, those economic rents that are earned should not appropriately be assumed to accrue to the land and resources. Those are rents that have been earned by those factors of production. And so they shouldn't, I mean, in the calculation of rent, you should not be including them. And you shouldn't be taxing them for purposes of compensation because they're really not yours to tax. Yours, when I say yours, I mean the owners of the land and the resources.
The government is what is the entity that taxes.
That's, well, the government taxes and the government could keep them or it could decide to share them in our context with the Anishinaabe. Right? So, I mean, it's another difficulty with economic rents. There's nothing wrong with the concept of economic rents. And we do use it as economists to guide us to optimal tax policies and so on. But to use it as a basis for determining compensation, I continually come back to and say, these examples illustrate how difficult that is. And you have to make a lot of assumptions and you have to sort of make decisions along the way that are absent in the more traditional approach of the counterfactual solution that is determined by what you see, actual data, historical data on revenues and expenses. It's not perfect, but it's a lot easier to deal with than economic rents.
And that brings us to your point about historical data, which, can you explain that on slide 19 then about the difference with historical data in the context of economic rent?
Yeah, and that bullet again is a segue, I think, to the next slide where I'll
Okay,
get
we
into
can move
that
on then
in
to
more detail.
Slide 20?
Yeah.
Is that the same?
It's
point?
slide 20. Yeah, I'm
Okay.
on slide 20 now too. So when I criticize the use of existing data to determine the quantum of economic rents, it's because if that is the counterfactual that is assumed to have occurred, then what I'm saying is the data would change because of all these other factors that I've mentioned. We've
Can you go
got,
back to your first sentence? Because there's a pronoun in there. I wasn't sure what it referred to. If,
and I'm sorry, I'm trying to rewind and it's,
I personally have lost my transcript, so don't give it back to me. Yeah, just,
So when I criticize the use of existing data to determine the quantum of economic rents, it's because if that is the counterfactual, that is assuming to have occurred, then what I'm saying is the data would change because of these other factors that I've mentioned.
that and that.
thank you. Yeah,
Okay, go ahead
now I
with
get
that.
it. Yeah. What I should have said is if we use the economic rents framework and also the joint venture framework, which again, I keep saying, we'll talk about that a little bit later, but that's what I'm getting at. those frameworks as an alternative to using net crown resource revenues are fraught with these difficulties.
Okay.
We're, now we're
I was going to ask if, are there other
still on,
issues that you want to raise on slide 20, or
Yes.
can we move them to 21?
no, we're still on 20, I hope. Okay.
You still want us to
I-
stay?
I-
You
yeah,
have a few
I-
more points to make
I
on
want
slide
to
20?
make some points on that slide. I want to explain why I'm talking about partial equilibrium models and general equilibrium models. And I will really try to avoid getting into a lot of technical terms and so on. There are some fundamental points that are important here, though, and that's the way to sort of point them out. And it goes to the idea that, you know, we're all using these existing data in our factual and counterfactual scenarios, including economic rents. What would happen in the economic rents scenario in the real world if you tried to do this, if you tried to tax all of those economic rents, you would see a lot of things happening in that sector, and they would have feedback effects in the rest of the economy as well. In simple microeconomic terms, we make a lot of assumptions like the competitive model and so on. We call it partial equilibrium because an unstated assumption is that everything else stays the same. In economics, most of the analysis we carry out is at the margin. They're marginal changes, and as long as they're marginal changes, it's a safe assumption to say that nothing else changes. We say ceteris paribus in Latin, in economics a lot, ceteris paribus, this and that. It allows us to have a simple look at something, that's what micro is, small markets, and see what will happen as a consequence of a marginal change. But in this context, that degree of taxation, it would be a significant increase in tax burden.
That
The
increased
imposition,
economic
the
rent.
imposition of 100% tax of economic rents.
Okay.
It's not a small marginal change that you could look at and fairly accurately predict the outcome just using what we call partial equilibrium analysis. A simple demand and supply curve is what that's all about, with everything else staying the same. A large tax change, or anything large, we call it a shock. And it would have feedback facts in that sector and far beyond that sector. And we can measure those things. It's not impossible to measure them. There are tools that we use to do that. And it's all referred to as general equilibrium modeling.
But you haven't done that in this case, is that right?
No one has done that in this
Okay.
case, including Dr. Stiglitz and Mr. Hutchings. And my point is, if they should do that. If they want to use the economic rents framework, they would have to recognize that imposing that degree of taxation would have consequences. And I've already talked at length about the consequences as far as the economic rents in the sector are concerned, but it would have feedback effects beyond that as well. And that happens. I mean, these things happen. We don't see as significant increases in taxes as that often, but they can happen. Other things happen. And we measure those using these models. If a client comes to me and wants to advocate for a significant refundable tax credit, for example, we would model that using a general equilibrium model. And we do that all the time. And the point that I want to make is everything moving forward from that point is different. And if you do that in, let's say, 1920, then that whole time path in the economy is different.
And I think that takes us to your next slide.
Yeah, the practical difficulty of
When you
doing
make
that.
the point about historical data sources, can you take
Yeah.
us through that slide?
But if I can, yeah, I'm sorry, indulge me. Statistics Canada keeps input-output tables, and they regularly update them every few years.
Mr. O'Riordan,
make-
what is this relevant to?
The idea that the economy changes and everything changes, and we shouldn't be just using the same data set that we've used before those large shocks to the economy.
Okay, and again, are we then on slide 21?
Yes.
Can you take us through your points on slide 21?
Well, the first bullet is simply to point out with sympathy to, I guess, Dr. Stiglitz and Mr. Hutchings, although I would advocate this should have been done, and it could have been done for more recent years, it would be very difficult to go back that far in time and make those adjustments because we don't have sufficient data. They were never gathered and collected. So I guess back to my overall comment about these rents being conceptual, as I say on the second bullet point, they do exist and they can be measured. But there is so much uncertainty around how to do that. And the potential for misestimation is very high. And the historical data is not appropriate to use for it. So the bottom bullet is simply the conclusion that, you know, we would suggest that it's not an appropriate framework to use for the purposes in front of us here.
All of which is based on a presumption that the opinion of Stiglitz and Hutchings was that Canada should now and should have had a taxation system modeled on collecting 100% of economic rents.
Yes.
So I see that brings us to the end of your slides on the first point, which was approaches to compensation. And unless the court has any questions on this economic rents idea, I think we should move on then to frameworks for determining sharing.
Thank you.
So are we okay to
Yeah.
continue?
If we could take a short 5-minute break, Your Honor. if
That would be
that's
helpful.
okay.
Yeah.
thank you.
Just
Thank you.
5 minutes.
Yeah.
Just short.
Take a break. I'll stay here.
All right.
I'm staying.
Okay. This court recess for 5 minutes.
So Mr. O'Riordan, we're about to get into your comments on frameworks used to determine sharing of resource rents or NCRRs. And we're on slide 23. Can you take us through that?
Yes, thanks. The frameworks that we are covering in this section are ones that have been proposed by Dr. Stiglitz and Mr. Hutchings, and also some additional ones that Dr. Mintz and I are suggesting could be instructive that are from our report. Dr. Stiglitz and Mr. Hutchings set out 3 separate frameworks, and the first 2 were bargaining model frameworks. And the third was a shared risk or joint venture framework. Since they concluded that their shared risk or joint venture framework is the more reliable approach, I'll just focus on that and dispense with discussion of the bargaining model frameworks unless there's interest in discussing those.
I think we can move on to your slide 25, which
25.
discusses the shared risk or joint venture. And I should note that there's a spelling error in Dr. Stiglitz's name. But
I was I was going to fess up to that too, because I do find that embarrassing. My name is misspelled so often. I'm usually sensitive to that. So I apologize to Dr. Stiglitz for that error. That's my own. So they set out a full risk model for the Crown, as we talked about some time ago in our introductory comments, and they compare it with a risk sharing or rent sharing model for the RST First Nations. And they conclude that this constitutes a partial equity interest. When Dr. Mintz and I look at this, and again, these are points that I won't dwell on because they're beyond our, our expertise as economists, but again, back to our literal reading of the territories, we didn't see any base
reading of
I'm sorry, the treaties, the treaty territories, the treaties. We assumed that there was ownership of land and resources and the risk associated with the resource development that was transferred with the conclusion of the treaties in return for payment of the lump sum and annuity amounts, with that promise to increase the annuity if it could be done without incurring a loss. And normally joint ventures are predicated on some form of joint ownership, not always, but normally. And so we felt that was a point just worth raising, that we didn't see the basis for the joint ownership assumption. But I'm not putting weight on that because our main concerns are with the feasibility and the likelihood that there would have been a joint venture agreement that was struck that would constitute a fair counterfactual for comparison with what actually happened.
So
And
now we're on slide
now we're on
26.
26, and we don't see the sound basis in economics for that assumption that the terms of the treaty, the idea that there'd be a lump sum and an annuity, would constitute any sort of partial equity interest arrangement. We also, when we look at the kind of risk that the Anishinaabe bore, there clearly was a risk. We characterize that as what we would term a political risk as opposed to a market risk. Again, we feel that the market risk was entirely borne by the Crown, just as it was in those other treaties that were used for comparison. The treaty guaranteed a return to the Anishinaabe. And it wouldn't be a shared risk framework realistically unless they shared both the upside risk and the downside risk. And there really isn't any downside risk comparable to that the Crown would continue to bear that would come from the market. In other words, net Crown resource revenues can sometimes be negative for a period of time, but there's no provision in the treaty that says the Anishinaabe should suffer because of downside market risk. In other words, the treaty terms created a floor payment that could and should have been augmented. So they did bear risk. And the evidence is the fact that we're all sitting here in court. If the Crown had honored its treaty terms, that political risk would not have been realized in terms of a loss to the Anishinaabe. Well, I put that in brackets because I use that advisedly. I'm just trying to find a term that would differentiate it from actual market risk.
And you're talking here about, you mentioned it in one of your earlier slides. Can you describe what political risk you're talking about?
It's the risk, and again, I think it's in this bullet as well. It's the risk that the Crown would not honor its treaty obligations, and that was a real risk, and it did occur. The Crown did not honor its treaty obligations, and so they were at some risk. But a joint venture framework presupposes that there is a market risk. There's a lot of discussion around this market risk, but there really isn't evidence that there was a market risk that they suffered.
I'll just ask one question. I won't pursue it too much, but
yeah,
at whatever value your approach brings to the compensation or determines the compensation would be, whatever that number is. You don't say that was a pretty big risk. That might have been bigger than a market risk at any particular time.
Sorry, could you repeat the question? Justice
Whatever
Hennessy?
your approach, whatever approach you support
Mhm.
would result in an amount of compensation.
Yes.
Okay. And you don't say that amount is a greater risk than market risk suffered from time to time. Like you're saying, they didn't bear a full risk because had they borne a full risk, had there not been a floor on the risk,
Right.
as there was, a $4 floor,
Yes.
and that wasn't really a full risk.
Right.
There was this other kind of risk, you say a political risk, but I'm just saying in numbers, the amount that the Anishinaabe did lose as a result of that political risk. You don't say that's a full risk?
I don't say that it's a market risk. I say that it's a significant and real risk, and the quantum is large, as we know, or it can be large depending on how you calculate it. So
Well, it's going to be large no matter how you calculate.
yeah. But the real risk to them was not at the market level. I mean, the Crown was responsible for managing the resources, and the Crown was vulnerable to all of those boom and bust cycles that we see in natural resource markets and so on.
Okay.
If that risk were really shared with the Anishinaabe, then there should be provision that they would actually pay the Crown revenue shortfalls when they occurred, you know, and there's nothing
they-
like that in.
Didn't fulfill their promise.
Yeah, no, if the Crown continued to lose, the
Oh.
joint venture can't be one-sided, where one partner only gets the upside and the other partner takes all of the risk, the upside and the downside.
I think the answer that helps me understand it wasn't a market risk.
That's what I'm trying to
Okay.
say. Yeah.
So then maybe we can move on. I think you're finished. Yeah, we'll move on to slide 27 then. Are you ready to move to slide 27?
Yes.
And some of this you may have already covered.
Yeah, and so I
Maybe
can
not.
cover this fairly quickly, because again, this is just our opinion of the methodology used by Dr. Stiglitz and Mr. Hutchings. They say that a minimum of 84% of net Crown resource revenues or rents should be shared with the Anishinaabe, 16% retained by the Crown. And the way they arrive at that calculation is by looking at the annuity, the $1.60 amount per capita in the Superior Territory, and comparing it to what they consider to be a $10 buyout price for land. And we just don't feel that that is an appropriate methodology to be determining the sharing of the revenues. It's based on some assumptions that we think are faulty. That $10 per person, for example, we're still on 27, which they characterize as a full risk model to the Crown. The $10, and I think I continue on this on slide 28. It's perhaps best to flip to that now. They think it would be the buyout price for the land, but the perceived value of the land at that time was nowhere near that. I mean, this comes up in the historical record, several of the background studies, but specifically it comes up in Justice Hennessy's decision, where there's documentation around that per capita annuity of $10 that some of the chiefs were asking for. And I would characterize that more as a bargaining position rather than an actual valuation of the land. A lot of the other historical evidence would point to fairly low values for the land in the Superior Territories. And again, I'm not pushing hard on these sorts of things. They're just commentary as I go through on some of our reaction to the conclusions in the Stiglitz and Hutchings report. From that calculation of a ratio, that's where they get their 16% partial equity stake for the Crown. In other words, it's as if the Anishinaabe sort of took out a mortgage, which didn't happen, but the Crown made a partial down payment on resources that the Anishinaabe continued to have a majority share ownership around as part of their arrangement, and that is, it's just made up. There's no necessary relationship around the quantum of the annuity and the augmentation factor for the annuity and any sort of joint ownership or any sort of shared risk.
So can you then take us to some of your, I think we're finished with slide 28. Could you take us to some of your alternative approaches then? And
Yeah, so
I think now we're on slide 30.
yes. So we recognize, our criticism of the existing proposed sharing approaches requires some level of guidance that we could offer as economists to how sharing could have and should have occurred. And we set out a number of examples, and we don't have any sort of advocacy position behind any of them. They're all suggested different ways of doing it that could be helpful to the court. So the first one is just to do it by sheer population. There is a certain logic behind that. You want to share the resources and returns from the land. Everyone should benefit from that. The Anishinaabe should benefit from that. They haven't been given a share through the augmented annuities, and you could augment the annuities based on population. This is something that I'm not sure if it's on this slide or the next slide, but yeah, and when we say that, we're not suggesting that they would actually be dispersed in any sort of arrangement where there would be per capita payments made to individuals or anything. We recognize that this is a transfer of resources to the Anishinaabe. It's their decision how they would want to allocate that themselves. But we come back to per capita calculations and so on, because it's helpful to sort of give an appreciation of to what extent that would change the economic circumstances and the welfare and the quality of life for the recipients.
You do mention
We-
on slide 30 that Mr. Hutchings proposes a population-based approach. Can you explain?
Yeah,
that?
if you look at Mr. Hutchins' report, he had to, make some sort of proposal around how whatever compensation would be shared with the appellants, First Nations, and his solution would be, absent a better approach of doing it, do it on the basis of population. It's just one example of several where, population has been used in the determination of damages or compensation, and he's doing that himself.
So-
Another one we used, looking at
And
Czechoslovakia.
now we're on
with-
slide 31.
I'm sorry, yeah. The partition of Czechoslovakia, there was a population share-based approach to asset sharing. So it's not directly comparable to our circumstances where we're talking about income, but it's another method of doing that was seen as being objective and have some basis in a fair, a just outcome. So moving on, I mean, we recognize that this would, in terms of current populations, this would be in the order of a 10% share. And we recognize that that could be easily viewed as insufficient, inadequate in terms of the compensation that's appropriate. But we come back, as I did earlier, talking about the approach to net crown resource revenues. If that is the case, it could be augmented in a two-step process with consideration for the income gap or income or wealth gap by applying some sort of escalation factor to whatever solution was derived on the basis of population. And that's all we had to say about population.
Based on the wealth gap, that second step.
Based on the wealth gap, yeah.
Thank you.
The second approach that we included was just a simple, in this case, 50-50 share rule.
And now we're on slide 32.
Yeah, my apologies for.
No,
on slide
that's fine.
32.
That's fine. I just, for the sake of the record, it's helpful
Yes,
to go
yes.
back and know that we're talking about slide 32 now.
Thank you. So under some circumstances, this would result in the same outcome. If population shares were the same, then the 50-50 allocation would be the same. But we recognize as well that it could be not as good a fit depending on facts and circumstances, such as when population size does change, then it would, that sort of allocation would favor the smallest jurisdiction if you translated it into sort of a per capita amount. And so that could be taken into consideration as well. Similarly, the average or median income of one of the, jurisdictions compared to the other, there could be a variation there. And in some circumstances, the 50-50 split might be viewed as appropriate if it would be viewed as a method of narrowing that gap. But it could, it could work in the opposite direction as well. All that simply to say is 50-50 rules are simple, simple to apply. They may be more appropriate in some circumstances than other circumstances. And we don't opine on, in this case, whether that would be a preferred method, but it's clearly one that, could be offered for consideration absent the proposal from Dr. Stiglitz and Mr. Hutchings.
Or do you mean as an alternative to
As an
The pro-
alternative
the
to,
proposal?
yeah.
Thank you.
I-
Looks
I
like
think
you're
we
ready
can
for
move on.
slide 33.
Yes. So here, Dr. Mintz and I are aware that there are revenue sharing agreements that have either been entered into or are being contemplated with First Nations. And so that's yet another approach to revenue sharing that could be on the table for consideration. And the caveat I would add to that is neither Dr. Mintz nor I have examined those resource revenue sharing agreements in any detail. We are not sure that any of them are directly applicable or appropriate for purposes here, but it is yet another method of sharing the resources. And so we wanted to include that. We also said in the last bullet that it's possible that it might be more appropriate on a go-forward basis than a compensation or a reward for past compensation, because once again, what we're always mindful of is the feasibility and accuracy of those sorts of agreements having been struck at some point in the past. And it's much more likely now and going forward that you would see some sort of resource revenue agreement than you would have seen, say, in the latter part of the 19th century or the middle part of the 20th century, in our view. And that completes the second large bullet, and we move on to just the evaluation of deprivation using concepts of relative income or wealth. So as I've said,
That's fine. Then we're on slide 35 now.
yes.
Thank you.
So the Court of Appeals commentary around the income gap or the wealth gap, we interpret as not being determinative in the sense that, this award should eliminate any difference in relative income or wealth. That's not what the court seems to be saying. It's saying that in addition to other considerations, this is a relevant consideration. And they go at some length to illustrate that with examples of deprivation and pointing out that neither party would have wished any sort of deprivation to be the cause of an inequitable resolution of revenue sharing with illustrations, because clearly there is deprivation that has existed in terms of, and I think they cite
They being
I'm sorry, the Ontario Court of Appeal water advisories on certain reserves and so on as examples of deprivation.
were we finished with that?
Well,
Wait.
the last bullet, I
Mhm.
mean, it's not essential, but I mean, if you're going to directly factor it in, then it seems that you should be trying to determine to what extent it's responsible. The failure to augment the annuities is responsible for that income differential that now exists. And that's sort of, again, a segue or an introduction into the next stage where I wanted to
The next slide,
comment
slide
on-
36.
Yes. I mean, labor economists, do carry out studies of the determinants of income, and it's fairly straightforward methodology to see that. I mean, different people earn different levels of income as a result of some explanatory variables, and I use the terms dependent variable and independent variable, where a dependent variable is just what we're trying to determine. That income gap, in other words, is the dependent variable. And we can explain it with different factors. We call them independent variables. And one example is education. Normally, there's a direct correlation between level of education and income. Justice Hennessy has mentioned the gender gap. Gender is a significant variable if you're talking in terms of statistics that would explain the difference between compensation earned by males and females. And
Explain but not justify.
explain but not justify. Age is another one, and labor force participation is just important to recognize, because not everyone participates in the market labor force. Some people choose to do work at home, others choose to participate, and so on. So if you're looking at a large group and you want to find the determination of their income and compare it to another group and there's a gap between the two, part of it can be explained by the degree to which one group participates in the labor force and the other one doesn't. So those things are relevant, and they're not all inclusive. We're just mentioning them, identifying them as examples of how one would go about determining a causal effect of a gap that's caused, by the failure of the Crown to augment the annuities.
And when I read this in your report, I was wondering if you suggested that you could unravel or untangle the failure to implement the promise from other actions of the Crown over that 170 years.
Yeah, that would be it's a challenge to identify this in particular, and the way that we would do it, economists do this, is to look at the unexplained residual of the difference, and presume that is actually the causal relationship. But you're quite right to point out that there are other things that we haven't taken into account that could be contributing factors as well. There's no sound methodological way to identify that factor, but you can certainly narrow things down to, a reasonable presumption that is the factor. It's clearly a factor here. I think.
Well, it just seemed to me such a provocative statement. It seemed to me
Okay.
such a provocative statement to suggest that one would, I'm thinking of a strand of, I'm thinking of a length of wool, that you would find one of those, that you could think that you could identify one of
Right.
those threads more than another, or that they weren't all so tangled together that
yeah.
you could never do that.
Yeah,
But that's just what I thought.
I
But
think your
you
instincts are.
You seem to say, as an economist, that's where you go.
Well, that's the next best solution. You can't identify that single thread. I don't think anyone could claim to identify that. But what you can do is scientifically, statistically eliminate the other contributors to the gap, and then make a presumption that the remaining part of the gap is what you're looking for. In our case, the failure to augment the annuities.
Can you describe for us what other kinds of factors, if you think about this analogy to a twisted piece of wool, what other kind of factors are you talking about besides the failure to pay annuities that would have contributed to the income deprivation? Is that what we're talking about?
Well, that's what I'm thinking about.
And that's what I thought. So can you, if we're
Well-
thinking of that wool as all the reasons for what we see now as the difference in wealth, incomes, no matter how you measure it, between the Robinson Superior Indigenous population and the non-Indigenous population. If we think about that piece of wool as a number of factors, and you've talked about the possibility or the difficulty in
Yeah.
what would some of the other factors potentially be?
Well,
Any
I talked
comment?
about market income, and there's also transfer income. And so one of the differences may be that the Crown has actually allocated more revenue through transfers to individuals for the non-Indigenous population than for the Indigenous population. That's one other factor that you could also try to pinpoint and identify. A third one would be discrimination. Simple as that. I mean, and that may well be another explanatory variable. I wouldn't hazard a guess whether statistically it would be significant or not, but there's no question there's discrimination against Indigenous people. And so to the extent, just as same as the gender gap in a sense, right? That is the way I would explain that. It's not that we wouldn't propose to use gender because males are better than females or females are better than males. We would use it because we're recognizing that there is a gap and it could be explained in part by that, but that is discrimination.
You recognize it because you have very smart people, statisticians have eliminated all other reasons.
Yeah. The remaining residual is discrimination.
Remaining residual.
Yeah.
Thank you.
Or we would call it the unexplained residual. And in actual terms, these are regression analyses that are done, and there's a dummy variable that's put in that equation, and that dummy, if it's statistically significant, that's eureka, because it does explain something. And if you can't explain it in any other way, then by process of elimination, it's probably the failure to augment annuities.
And has anybody done that kind of analysis for this case that you're aware of?
You know, no, I'm not aware in this case, and I'm not aware in very many cases. Economists used to look at these things back in my early days as an economist, and I think people shied away from it because it was controversial. There are different schools of thought about the extent of discrimination, and some economists who would study this would be labeled as trying to justify discrimination. You know what I mean? Because in simple terms, you're looking at wage differentials and you're concluding that it's all discrimination
Understand.
where it isn't.
Have you finished then dealing with slide 36? I think we have. Is there anything else you want to add? Or
No,
shall we move to 37?
we're done with 36. Yeah.
All
Yeah.
right, so then we can
yeah.
move to slide 37. And you can explain for us the differences. We heard a little bit about this already from Professor Mintz about the differences between the benchmarks for measuring income comparisons. Can you take us through that?
Yeah, and this slide starts that. I mean, it's just, there are different definitions of income. Some of them are cast much more broadly than others. And we start with looking at market income, which is, we've talked a little bit about that. It's everything that is derived from employment, whether it's self-employment or employment, in a company. All of the earned income is another way to look at it, market or earned income. And then total income is broader because it includes those government transfers that I mentioned in response to Justice Hennessy's comment. A lot of income that people get is a result of transfers. They could be broad-based transfers like the CERB when COVID took place. That obviously increased national income. And then we layer in the idea of what the famous impact of taxation. We all keep coming back to taxation, death and taxes. We feel that after-tax income is relevant here because it does make a huge difference. Canada has a progressive personal income tax system, meaning we have progressive brackets of income at the higher ones of which are subject to higher rates of taxation. And the purpose of that is to reduce the income inequality that exists in the country. And it is effective. If you look at pre-tax income, however defined, broadly or narrowly, compared to taxable income, it really does narrow the gap. In other words, lower the degree of income inequality in the country. We felt it was relevant here as well because it is an important factor to take into consideration the fact that under some circumstances, Indigenous persons aren't subject to taxation. So it
Income.
depends. I'm sorry.
Income taxation.
Yes, yes. Depending on whether it's earned on or off the reserve and so on. So in some cases they are taxed, in others they aren't. But you can take that into account, and you should take that into account in any sort of measurement of relative wealth or income.
So I think we're then on slide 38.
The last point on that was
Oh,
simply
sorry.
disposable. I mean, that is where you get to disposable income. And in terms of quality of life, that's what's important. It's what is left for you to enjoy yourself after the government has taken its share. The next slide, 38, we have a simple discussion around the difference between average total income and median incomes. And in our report, we had a table, and you can see that it does
Would you like to pull up
define
that
them,
table?
right?
Would you like to pull up that table? It might be helpful.
Sure.
It was table 9. If you're going to refer to it, I think visually it might be helpful to look at it. It's
Yeah.
page 89 of your report.
Thank you.
Can you just wait until we'll try to get that on the screen?
Yes, yeah.
Thank you, Ms. McNamara. So you're talking about the different types of measurements, and I think you were referring to this table.
Yeah, and I'm just trying to get my slide back. Sorry.
It was
Evans.
38.
Thank you. So the reason that we make this distinction is because the average income can be distorted because of the distribution of income. If you've got a significant number of very high income individuals, it can increase the average. By the same token, if you've got a lot at the lower end, it can reduce the average. And the median is a measure, a statistical measure that takes those out of consideration because you're just looking at the 51st percentile of income. So if you've got a normal, I shouldn't do that, a normal distribution or whatever, I mean, it will make a difference. It won't be a huge difference. And I think the table was useful that we included because it illustrates what difference that makes. And in some people's estimation, that may be a trivial difference. But it is fairly significant when you
You're
look
talking about the difference between
the
using
difference
average
between
total
average
income.
and median. Yeah. And then the median after tax. And those are all done on a per capita basis, just for comparative purposes. And you can see that it's thousands of dollars of difference. But those thousands of dollars of difference, once you add them all up and discount them and look in terms of a compensation award, can make a fairly significant difference. And in our report, if I can quote from the report,
Sure.
and I think this bears explanation because it may have come up already. There's maybe a little bit of confusion in the report. We're talking about, I'll find it and quote it.
You've got, you said-
Page 88. We have a phrase that says, this means that the transfer needed to equalize after-tax median income of Indigenous and non-Indigenous populations is only 69% of the transfer needed to equalize average total income. Okay, so if you look back at the table, with reference to the table,
Just let's pause for a moment.
Sorry, was-
Justice Hennessy, we have that highlighted on the screen.
Okay, and it was
It's
page 88 or 89?
page 88, paragraph 214
Got it, thank you.
of the Mintz and O'Riordan first report. And you might recall that Professor Mintz, I think, was taken to this in his cross-examination, if it looks familiar.
Thank you.
Sorry, Mr. O'Riordan, you were explaining.
no, that's good. So we're back on the table now. And we include some percentage differences in the third column. And you can see that the difference between these percentages is relatively narrow when expressed on a per capita basis. And you kind of wonder where the 69% came from, because we didn't really explain that in the report. We didn't realize that, but I can explain it because I think it would be helpful. It drives home our point. It may not look like a big deal in the table, but as soon as you look at it as overall compensation, it can make a significant difference. And again, our position is that median after-tax income makes the most sense of all the measures of income and the income gap that exists. And I don't know if we can get page 88 back up on screen a little bit lower. If not, I can read it. And we may not have highlighted it there. Just allow me to read then. No, it's the starting, for example.
How many lines up from the bottom?
3, 6, 7.
Thank you.
And she's got it highlighted now.
Okay.
And the next sentence I would highlight as well. So just reading it. So for example, band trust rates to bring forward values. Professor Stiglitz and Mr. Hutchins estimate the income gap amounts to 54.4 billion in the RHT territory and 29.4 in the RST territory for a total of 83.8 billion. The total payment would be 57.8 billion. In other words, 26 billion less if after-tax median income were used instead of average total income. If you take 57.8 billion over 83.8 billion, that's where you get your 69%,
Thank you.
just to explain that.
Thank you. Can I ask Mr. O'Riordan, this figure includes the Robinson Huron territory, which is not before the court right now.
Right.
Would the same math apply even if you were to take out the influence of the Robinson Huron territory?
It should apply. Yes, I haven't done that calculation, but it should apply.
I think we're now on slide 39. Are you ready to move to slide 39?
Yeah, so slide 39 sort of completes the range of alternative measures that you could use. And when Dr. Mintz and I discussed this, we did hesitate a little bit to include this. We didn't want it to become controversial, but in the end, we thought we would include it for completeness because it is another way of looking at deprivation. And if you look at deprivation as trying to help the people most sort of in the worst income situation, the poverty line and so on, there are measures of this that Statistics Canada uses, and other organizations, other governments use it internationally, and that's the low income measure. So 50% of the median after-tax income. You could be targeting compensation in order to eliminate that, as opposed to looking at a broader measure. It's a narrower measure, and our hesitation was we don't want to look as if we're trying to argue that if you're above the poverty line, you know you don't have issues. Everybody has issues. We see that, but it's there for a reason. And I mean, all of us. I mean, the government in the latest budget and elsewhere, we're always reporting periodically on the degree to which we're able to eliminate poverty in Canada. And that is one measure to use. And so if you're considering deprivation to be, you know, another way of saying some portion of the Indigenous population is living at standards that are unacceptable, you could use that as your target to eliminate that. And once again, you know, I hasten to add, we're not advocating that. We're not advocating any of these. We're simply putting them all out on the table so that at least you've got a complete range of measures that you can look at. for this purpose.
There was just one pronoun. You say, so if you're considering deprivation to be another way of saying some portion of the indigenous population is living at standards that are unacceptable, you could use that as your target to eliminate that. You could use the low income measure
Yes,
as your target to eliminate poverty.
yes, thank you.
Okay, it was probably clear to us.
And our last bullet, I guess merits just an explanation too, because we have this tendency of converting everything to per capita amounts. We recognize that it's not our business to determine how any compensation should be distributed. But it's useful as economists to look at per capita measures because it translates into real people's lives as opposed to a large lump sum payment. So we were at pains to, or I was at pains at least to include this this bullet, acknowledging that that's beyond the scope of our responsibility or ability.
I think this brings us to your concluding slide. Are you ready to go through that?
Oh, yes. I'm sure everyone is. And I simply included the concluding slide because I knew it would be a long sledding through it. So I wanted to just recap with the takeaways as we would normally do, or I would do in a presentation. So a lot of the time that I've spent on the stand is to try to argue that the economic rent framework is just not a reliable framework, and it makes it an unsuitable framework to determine any sort of counterfactual scenario. We need a counterfactual scenario. And going down this path is just fraught with a lot of difficulties that we don't encounter in the alternative of using the net crown resource-based revenue framework. And I put a lot of emphasis on reliability as well as suitability. I'm more competent to make judgment over reliability perhaps than suitability. It is what it is. It's not perfect, but we think it's the best method to construct a realistic counterfactual where the Crown had in fact honored its treaty obligations. Similarly, with the joint venture resource management framework, we just don't see that there's a sufficient basis for that it should come into play as part of the determination. And that's why we offered alternative frameworks for the court's consideration.
Can I just interrupt you there? By the joint venture resource management framework, can you just again summarize for us what that framework presents? What sharing arrangement you're talking about here that you don't accept?
This is where, and they use the terms interchangeably, shared risk or joint venture and so on, but it all means that you presume that there should have been a joint venture relationship, and the relative shares in that agreement would be a 16 to 84% split, with the 84 or 83 in one treaty being in fact a floor, because in some places they argue that even that is not sufficient, but they do settle on this split determined on the basis of the ratio of the annuity to the derived presumed lump sum buyout price, and come up with that 84-16% split. They also look at equity returns as well, but as I said, Dr. Mintz and I have not looked at any of that because that goes to the idea of how you bring things to present value. And we offered our commentary on evaluating deprivation using these concepts of relative wealth and income, which we recognize is probably a useful component of the appeal court's decision, because in our view, it allows you a lever to make an appropriate adjustment if the if the adjustment without that consideration is viewed as unsatisfactory for some reason.
Thank you very much, Mr. O'Riordan. That concludes my questions. And I wonder whether you might want to take a break or whether we're ready to move right into.
How are we on
Cross-examination.
time? What's your thought? Do you want to
My
break
thought
before we
is
start?
We do have time for a break, like, I won't need all of tomorrow,
Okay,
if I start today, and,
all right.
I do need. Yeah, we're only going to 4:30 today, it's only 3:10.
Okay, let's do that.
But if we have a small break, I can move my stuff up and.
Thank you very much. We'll take 15 minutes.
All rise.
Stay.
This court recess for 15 minutes. This court will now resume. You may be seated.
Morning, Your Honor. Just want to notify the court that Ontario has no questions for this witness.
Thank you very much.
Good afternoon, Mr. O'Riordan. It is O'Riordan.
O'Riordan, thank
Yes.
you. Yes, it is.
Okay. My name is Harley Schachter, and I represent the plaintiffs in this case, White Sand and Red Rock. And I've got a couple of questions for you, and hopefully we can get a lot of them done today, this afternoon.
Okay.
In front of you, I've put on the desk by you two very thick binders. Now, those were the cross-examination compendium that we had prepared for the cross-examination of Professor Mintz.
Okay.
And it's just convenient to use them to direct you to documents that I would like you to consider. So the first thing I want you to do is, could you take volume 1 of the compendium? It's exhibit L.1, tab 1. Those are the instructions you received called the terms of reference.
Yes.
You recognize those?
Yes, I do.
And at the bottom of each page on the right-hand side of this document, of this very thick Sherlock's bound document, there's numbers, and you'll
Yes.
see that the first page of tab 2, it's on the right-hand side, page 5.
Yes.
As much as possible, unless it's blurred out by something, I'm going to refer to the page numbers of the compendium, which is the big Sherlock's bound document, in order to help you locate documents, okay?
Thank you. Yeah.
So at page 6 of the terms of reference, tab 1, at the very last paragraph, you were given some instructions. And it says, stage 3 will, among other things. And then we've got A and B, and I want to focus on C, because it says that the stage 3 will determine compensation owed. That's in the past,
Yes.
to the plaintiff First Nations up to the date of trial, based on the amount of NCRR to be dispersed pursuant to the augmentation clause. You see that?
Yes, I do.
You were told as part of your instructions to assume that the compensation for the past would be based on NCRRs, correct?
Well, we were asked to determine the compensation based on that. I don't know if that is the same thing as saying that it would be based on that, but Dr. Mintz and I were asked to.
You were instructed, sir.
Oh, okay. Yeah,
It's
I'm
not a
sorry.
fault of yours
No, no.
how you were instructed. You were
Yeah.
instructed how you were instructed. I'm going to suggest to you, and I hope it's not a surprise, that the work product you produced is a function of what you were asked to do. Is that fair?
Yes,
Rise to suggest that you turn the page. Or that your witness turn the page as well, if given the opportunity.
yes,
Yes. I- Is turning the page. I think my friend is trying to allude you to and to direct the court to the fact that you were also asked to comment on the value approach. I appreciate that.
yes.
I'm not hiding from that. My point is that you were instructed that the compensation would be based on the amount of NCRRs. That's what you understood your instructions to be, I hope.
Yes,
And it stands to reason, I would think, that your work product was influenced by what you were told. Isn't that fair? Sorry, your work product was influenced by what you were told to look at. That would make sense to me.
yes, I mean, I don't have a problem with that. That follows.
Okay. Now, when earlier today you talked about just compensation and you used the word just. Is it fair to say that what you were struggling with was trying to provide the court with some guidance about what just compensation might look like?
Yes,
And is it fair to say that what you considered to be just compensation was your professional opinion, or was it a personal opinion, or how did you arrive at what you considered to be just?
I don't think I ever said what would be just. I was just trying to explain, and this is my professional opinion, not my personal opinion, how that compensation should be determined. The actual quantum of the compensation, which is the reason I was using the word just, is beyond my competence or authority. That's a matter for Justice Hennessy to decide.
But isn't it also a matter for Justice Hennessy to figure out how to get to the figure of just compensation? Or are you saying that, oh, sorry, I interrupted you.
No, I was just nodding, and I was going to say yes, because a nod doesn't really get recorded, but I was going to agree with you that it is within her competence to decide how that should be done. All we were doing was trying to provide some opinion in relation to the questions that we were asked. What our professional advice as economists would be
Yeah,
to do that. It's her domain entirely to not just to decide the quantum, but also the methodology, how to get there.
right. Is it fair for me to suggest to you that what you had told the court about was about what just compensation might include was informed by what you understand the history of the dispute was?
Yes, among other things. I just hesitate to answer quickly because I don't disagree with that. That would have been in our minds. Our directions from council were in our minds. Our reading of the terms of the treaty were in our minds, and particularly our reading of the two decisions at court were in our minds. All of those things directed us to the opinions that we expressed.
Thank you. I understand when I asked some questions of Professor Mintz that he had he gave an answer about having seen an annuity report. Do you remember seeing an annuity report?
No, I didn't. I can say it's probably worth just going beyond that statement just to sort of say, Dr. Mintz and I co-authored the report. We wrote different sections and put them together, and we focused on different elements of the report. We collaborated on the report. So as I illustrated in some of my earlier comments, we had some discussion around some of the points in the report. But that said, some of the things Dr. Mintz did himself, and I didn't read everything that Dr. Mintz read, nor did he read everything that I read.
Okay, so what did you read about the treaty, about the historical aspects of the treaty?
Well, I initially read Justice Hennessy's decision. I believe that was the first thing that I had read when I was engaged. And there was considerable amount of information that was contained in that decision. But then I read various reports that had been sent to us as useful background about things like Anishinaabe values and culture and so on, the value of lands, the historical interpretation. I read the treaties. I read some of the Robinson Vidal Anderson reports, and other things such as that.
Perhaps you could turn to page 7 of the compendium, and there's a list of reports that you were asked to read.
Still tab 1, yeah. Yeah.
Still tab
okay,
1.
Yeah.
Are those the reports that you read, or were there other reports?
Yes, I wish, thank you. I wish I'd looked down at the page more quickly because I would have seen some of the names I was trying to recall. So Heidi Stark and Paul Dribbin as examples of, Anishinaabe culture and so on. The value of the territories. Let's see. May not be cited here, the ones that I read. But the value of the territories, I also recall a reference, and we footnoted this in our report from Justice Hennessy's decision.
What about the value of the territory?
I was just trying to illustrate that with examples of things that we had been directed to have a look at.
Oh, I see. So you read the reports listed in your instruction letter,
Yes.
but that's the only reports you recall reading?
Yes, I mean, off the top of my head, I may, if we come to it, I may recall another one, but I didn't read an annuity report. If that was your question to Dr. Mintz.
Yeah, that was my question.
Yeah. No, I didn't.
I didn't see Dr. Paul Dribbin's report mentioned in your report. You did read Dr. Paul Dribbin's report.
I think it's footnoted.
It is indeed footnoted, but there's really no commentary on it.
Oh, I see. Well, we had commentary about the value of the superior territories, but it was succinct. We could look at it if we can find it in our report.
Maybe if someone can control F the word value of the treaty territories, because I'm maybe at a loss. I'm not sure I remember where you talk about the value of the treaty territories. Perhaps we can take a moment. And I'll wait for the magic of computers to give me an answer.
Yeah,
and to
word
help us
search.
out.
Yeah.
Council for Canada says they can help, yes. Well, yeah, my colleague, Miss Lewis, has said there is no reference to Dr. Dribbin in your report other than, wasn't there a footnote? Not in the main report. Okay, I'm
Okay.
sorry. So there's nothing there about Dr. Dribbin, but in terms of value, my colleague from Canada has suggested that maybe it has something to do with an article written by Douglas McCalla. Is that maybe ringing a bell?
Yes, we cited, I thought we cited both of them in a footnote, but perhaps it was in Justice Hennessy's decision, the Dribbin report. I can see a footnote, but I can't recall.
Okay,
I'm sorry.
no, that's okay. can we please turn to tab 2 of the compendium of Jack Mintz, volume 1 of 2, exhibit L.1. And this is a copy of the judgment from the Court of Appeal,
Which tab, please?
tab 2.
Thank you.
Tab 2, which page? Sorry.
Tab 2, and we're going to go to page 13.
Okay.
If you look at paragraph 1B near the top of, again, at the bottom right-hand side, page 13 of the compendium.
Yeah.
And it says at the top, it says page 8, permit the Crown.
Yes,
And then it's got B, to fulfill the obligation in A above. So this is part of paragraph 1B.
yes,
The Crown is required to periodically engage in a process in consultation with the First Nation treaty parties to determine the amount of net Crown resource-based revenues. See that there?
yes.
Now, would you agree with me that your report doesn't discuss the lost opportunity to engage in a process that took place?
I would agree with that. We didn't discuss that.
Thank you. Now, over on the next page, or sorry, at the bottom of page 13, the court judgment reads in paragraph 2, this court orders and adjudges and declares that the principles governing the treaty parties' implementation of the annuity provisions are to accord with this court's determination that A, the Robinson Superior Treaty was negotiated by the treaty parties around the Anishinaabe Council filer at Bawatang, Sault Ste. Marie, as a renewal of the ongoing relationship between the Anishinaabe and the Crown, grounded in the Covenant Chain Alliance, and as a basis for continuing a mutually respectful and beneficial relationship going into the future. And I want to stop there. I didn't see any reference in your report to how you considered the Covenant Chain Alliance to affect the your determination of compensation, if at all.
There is no such discussion in our report. I'm not sure that Dr. Mintz and myself are the competent authorities to make commentary around that commitment. I'm aware of that commitment and I'm aware of the Covenant Chain, but we didn't make reference to that in our report.
Sure.
I don't know where we would have made such reference given our instructions.
You say that you're aware of the Covenant Chain. What do you mean you're aware of it? Do you know what it is?
Yeah, I have an interest in Indigenous culture, and I collect early Canadian art, and part of what I collect is Indigenous art. So Mi'kmaq in Nova Scotia, quill work baskets and chair seats and things like this, Inuit sculpture, and I have beaded silk bags from the Six Nations Reserve. I have early 19th century watercolors of Indigenous people. Most of these objects I've acquired at auction in the United Kingdom and brought back here to Canada. It's a hobby of mine. I have an interest in Canadian history and art history.
So you understand the Covenant Chain to be an artifact that you might collect?
Yeah, well, I wouldn't be able to collect some artifacts, but those that are available, I do collect and I value.
Okay. Can we turn to page 14?
Yes.
Page 14, at the top of the page, this is part of paragraph 2B. The treaty reflects the parties' common intention. I want you to keep that in mind.
Yes.
That their agreement was to allow both the Anishinaabe and the Crown to realize the future opportunities and potential. You'd agree with me that's forward-looking, yes?
Yes. I mean, forward-looking from 1850
Oh, yes,
on.
yes,
So it's in the
yes.
past, but forward-looking from the past.
Yes, thank you for
Yeah, yeah,
correcting.
yeah. No, I didn't correct you. I just added to what you
Yeah.
said.
Of the treaty territory in a manner consistent with the Anishinaabe principles of respect, responsibility, reciprocity, and renewal, and the intention of the Crown to act honorably with justice or fairness and with liberality or benevolence. You see that there.
Yes, I do.
Now, to be fair to you, I think you talked about justness, and the court also talks about justice in that paragraph, but I wanted to ask you about respect, responsibility, reciprocity, and renewal.
Yes,
And let's start with reciprocity.
right.
Where in your report do you discuss reciprocity as a factor in determining what compensation should be paid?
Well, we don't discuss it in our report because we were writing our report from the perspective of economists, not as historians. And I mean, honestly, Dr. Mintz and I had numerous discussions, but we never considered that not talking about those principles was a gap or an omission in our report. But I'm happy to talk about those principles. I understand the principles and
What is the principle of
the
reciprocity?
reciprocity.
Yeah.
Well, it's not easy to hive off various components of these things. I sort of read them as a continuum, but reciprocity involves being treated the same way that you treat the other party. And it's sort of embedded in the idea of kinship that the Anishinaabe culture was based on, and the need at the time. I mean, it was recognized by the Crown or so-called Indian agents at the time, like Robinson, that there had a sort of a fundamental principle would be an establishment of a kinship relationship with them. Hence, brother, father, and these sorts of terms. I think that was the effort of the Crown coming from a European tradition to demonstrate reciprocity and kinship with the Anishinaabe.
So you
And I think that was the expectation on the part of the Anishinaabe, that it as a sort of I don't know if I'd use the term condition, but I mean an expectation that there would be this relationship, and it extended beyond that to the idea of sharing the good life, enjoying the good life.
Would you agree that kinship has something to say about a share that is appropriate in this case?
See, the only reason I hesitate is because as an economist, it seems to, I appreciate that, but I don't know how I would incorporate that as an expert opinion from me. In fact, I would worry if I tried to do that, it would be excluded, because someone would look at me and say, on what basis are you including those sorts of considerations in your opinion as an economist? With respect, because I'm not, I mean, those things didn't enter our minds. We were aware of them. They underlie the treaty and so on, as you rightly point out. But Dr. Mintz and I didn't discuss them in the sense of, we have to incorporate these as considerations in our professional viewpoints.
Okay, thank you, sir. Could we turn to page 85 of your initial report for a moment? I hope I said paragraph 85. Did I
Oh,
say
okay.
page 85?
Yeah,
Yeah, sorry.
yeah.
My apologies.
No.
At paragraph 85, Mr. O'Riordan,
Yes,
you write that in this case, the analysis is complicated somewhat by the further need to decide how these net revenues should be shared. The Robinson treaties themselves make no direct reference to revenue sharings. You
Yes,
then continue, the augmentation clause in the treaties sheds no light on the critical question of how to determine appropriately augmented annuity amounts. It simply states that if the territories ceded by the treaties produce an amount that will enable the government to increase the annuity without incurring loss, then the annuity will be increased from time to time. And I'm going to stop there.
yeah,
So would you agree with me, sir, that the treaty document, when it says that the territory ceded, the territory ceded produces an amount that's referring to a geographic construct of the treaties?
yes,
So we now know that at least it provides some information because it's about a geographic area. We get at
Yes.
least that much.
Yeah.
Now, would you agree with me that in economic terms, and I want you to stay in your lane of economics
Thank you.
as much as you can. In economic terms, if one has a geographic area, geographic areas do not in fact produce things without the intervention of humans. I suppose, say for maybe carbon capture.
mhm,
I think carbon capture exists whether or not any human intervenes or not. But for the most part, would you agree that geographic areas do not produce an amounts without the intervention of humans?
yes. I mean, I hope there's a follow-on question. That's all, because I'm,
Well, it's human activity within the geographic area that causes the geographic area to produce revenues for the
Okay.
crown, right?
yeah, you're getting at the idea that the resources are there, but it takes human intervention to extract the resources? Is that the point?
I
or-
didn't ask that question.
Okay, no, I'm just trying to, you talked about the geographic limits.
I'm just saying that the territory itself produces nothing without a human being
Right,
or a group of human beings doing something to extract wealth from that geographic area.
absolutely. So I'm on your wavelength now. Thank you.
Okay. At paragraph 88
Yes,
of your report, you noted that one of the things that the Court of Appeal observed was that you should look at the relative wealth and needs of the different communities. You see-
Yes.
You see that?
yes,
And I want to sort of, you've actually got in paragraph 89, you've actually got paragraph 322 of the Court of Appeals decision.
yes,
And it says, and I want to read it because we're going to have a couple questions about it. The parties in negotiations or the trial judge in stage 3 must determine the form, level, comma, and aim of the sharing that the augmentation clause requires, period. The parties in the court should be led, comma, in doing so, comma, by the treaty parties' shared goals, expectations, and understandings in 1850, comma, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal identified by the trial judge, and the Crown's commitment to being both liberal and just. Now, my question about that is that what's being referenced here is the shared goals and expectations in 1850, correct?
correct.
So that's a factor.
Yes,
And did you in your historical analysis or, sorry, in your economic analysis, I'm struggling because I'm not sure how you looked at the, what you considered the shared goals, expectations, and understandings in 1850 to be. Not sure what they were in your report.
Well, I mean, we understood them to be exactly what we've quoted in the report. I'm missing something, I think, in the question.
Well, all right.
mean-
So your report speaks for itself on that.
I suppose.
Okay.
Can I add just?
Yeah, you can add whatever you
Yeah,
want.
so where this comes to bear is in the stage of determining the sharing of the augmentation clause proceeds. So it's, again, I mean, I spoke about different approaches to sharing. And I don't, I mean, I'm not expert on economic history or Anishinaabe culture, but
Thank you.
we recognize the treaty language on the one hand, and we recognize the two decisions of the court on the other hand as well that are relevant in that determination. But no, we didn't. I mean, we didn't do an economic analysis of these principles of respect, responsibility, and reciprocity. Other than I believe in some places where Dr. Stiglitz and Mr. Hutchings had talked about bargaining, and bear in mind, they eliminated those for consideration. So I didn't talk about them today, but I think we questioned whether those approaches were consistent with Anishinaabe values, because you know what I mean, the idea of negotiating and extracting full value for yourself as a party, as opposed to sharing, because those bargaining models like the Nash equilibrium and so on, they're based on rational behavior, but some of that rational behavior, I would say, is sort of Western culture based. I mean, it's the idea that you want to maximize your share as opposed to you want to reach a fair apportionment or share of resources. So that's the extent, though. We didn't go any further than that because we just didn't feel it was, you know, either in our competence or all that relevant to the advice that or the conclusions we were reaching. I hope
Thank
that
you.
helps. I'm just trying to.
Yeah, thank
Yeah,
you. Thank you for that answer.
For council, I missed a word. What is talking about a certain model, bargaining model?
Nash.
like that?
NASH.
Yeah, capital N, someone's name.
Yes. I wonder, Mr. O'Riordan. I wonder, Mr. O'Riordan, if we could go to tab 3 of volume 1 compendium, exhibit L.1, compendium page 21. And here we
Yes.
have an excerpt of what the Court of Appeal said when they talked under the heading, what kind of sharing is required by the treaty promise? And at paragraph 322, this is where the Court of Appeal talks about the providing for both communities.
Yes.
It says 322, based on the trial judge's reasonings, comma, the common intention of the parties was to share in such a way that would provide for both communities. This would suggest that the share promised is to be determined not only based on the extent of Crown revenues, but also with reference to the relative wealth and needs of the different communities. Obviously, the Anishinaabe would not have expected their communities to suffer a range of deprivations, including substandard housing and boil water advisories. And it goes on. You would agree with me that what the Court of Appeal is talking about there is what's happened in the past. They're talking about the range of deprivations in the past.
Well, and that currently exist, I would
And that
add.
still
yes.
exist,
Yeah,
yes.
Yeah,
Yeah, but-
yes, yeah.
Okay.
Yeah.
Is it fair to say, sir, that you approach the task of deprivation on the basis of current population alone?
You mean as opposed to individuals who may have suffered deprivation in the past and are no longer living? Is
Yeah,
that what you're getting at?
that's what I'm getting at, yeah.
Not really. I mean, you know, when we talk, as I said earlier, we converted some sums to per capita amounts just for illustrative purposes. And the compensation that will be ultimately granted is an amount that is meant to keep everyone whole, whether they're living or dead. So to the extent that there was deprivation, let's say in 1870, because probably there's no one alive at this point from 1870, that deprivation should be included in the compensation amount. It's not meant to represent only the X thousand of Anishinaabe who are living today.
Yeah, I was troubled by that because it sounded to me like you were putting out this figure of a per capita amount, making it look so large as to be unreasonable.
No, not at all. And I appreciate that. That's more a comment than a question, but I mean, I appreciate it because I was trying to take pains to say, we don't want to be misunderstood when we're putting those per capita amounts on the table. We're trying to put them there to give some idea, in this case, of the difference between total income, you know, employment income, after-tax income, and so on, just to give an idea on a per capita basis, what that would translate into in terms of an individual. We in no way meant to say that, oh, we are only worried about individuals who are living right now and what they might ultimately receive. So we were, that was not an attempt to, I don't know how to put it, undervalue. Yeah.
Here's how I would put it. I mean, a lawyer I respect was once accused of something called narrative priming. That's where you use language and present language to try and influence the outcome. And I was concerned that maybe that's what you were trying to do, to make it look like, oh my gosh, look at all of these people, each going to be millionaires. You're not trying to do that.
No, and I'm sensing that that lawyer might even be in the room. I'm not sure about that, but just from facial expressions around the room here, if I
The
can
thing
say
is,
that.
Mr. Shack can't see what's going on behind him.
That's not what we're getting at, no.
All right. And indeed, you do understand that the annuity is a collective entitlement.
Yes.
It's got nothing to do with individual entitlements. Aside from the $4, I should say.
Yeah, I mean, that said, clearly all of the individuals are not disinterested in the annuity amounts because there's an expectation that their living standard will rise, the degree of deprivation will be resolved. So I tend to look at it from the prism of, you know, the average person and what impact it has on them. But I absolutely understand that it's a lump sum, not an individual payment.
So let's turn then to paragraph 94 of your report. At paragraph 94, you write, so you're talking about the value approach that Stiglitz and Hutchings used, and you say in the second line, it is hypothetical to assume that the amount should be based on a theoretical economic construct. That's a complaint about their value approach. Is it, you understand that?
Yes.
Okay. And you do understand that what Stiglitz and Hutchings were trying to do was to determine the value of the treaty territory on a wait and see basis. You appreciate that?
I'm sorry, could you say it again?
What Stiglitz and Hutchings were trying to do, I hope you appreciate, and if you,
Yeah.
if you've read the report, you
Yeah.
understand that they were trying through the economic rents approach to figure out what the value of the resources within the treaty territory were. You understand?
Yeah, so, yeah,
And do you know why they were trying to figure out the value of the treaty territory?
well, I mean, if you use the economic rents approach, then you have to start with a calculation of the total value of the territory, the revenue, the returns realized from the territory before you can back out the competitive returns and establish what the economic rent is. So,
But do
yeah,
you know why they were trying to get to the value of the treaty territory?
beyond what I already said, I mean, in order to determine an amount of compensation, but that's just a different way of saying what I've already said. So I'm not sure what I'm missing. That's all.
All right. What you say is it is hypothetical to assume that the amount,
Yeah,
that's the amount of past compensation,
yes,
should be based on a theoretical economics construct
yeah,
rather than the expectations that the First Nations would have had with respect to the augmentation of the annuities. You see
Yes.
that there?
yes, yes,
Am I correct then in understanding that you approached the task of your report with the view that the Anishinaabe did not have the expectation that their annuity would reflect the value of the territory that was the subject of the treaty?
no, I mean, their expectation, given the historical record, is that there would be, and the anthropologists and so on, the expert witnesses who have attested to this, they did speak about their expectations in terms of resource sharing. In other words, a means to arrive at the good life.
But
That's what we mean by the expectations of the First Nations. If I can try to help square the circle.
well,
'Cause
maybe I can try. I guess maybe we're going to have to go to, let's see.
Can I just say, I
yeah.
don't think it was in their minds that there was economic rents and that the Crown would capture all of those economic rents and then apportion them. I don't think that was in their minds. I think what was in their minds was this idea of them arriving at a place where they had the benefits of the good life and their social and economic conditions were improved by virtue of signing the treaty. And that's why our statement here is this economist approach, this theoretical approach to determining economic rents and so on. I doubt very much that was in their minds. And again, I hesitate to say those things because I know you can tell me I'm not an expert in those areas, but I mean, that was my understanding.
It was my understanding that the Court of Appeal said that woven throughout the judgment of the trial court, this court,
Yeah.
was the concept of value of the treaty territory. Do you remember that at all?
Would help if we cited it. I think that's.
Okay, well, maybe we can pull up the, just if you find the decision of the Court of Appeal and Control F4, the word woven,
Yeah.
and we'll find it.
Dr. Vince and I obviously digested the decision in whole. We focused on sorry, the commentary in the decision, but we focused on the decision itself at the appendix to the final portion of the document. And that's what we cited in our report.
Well, I
But,
mean,
but, you know, I don't doubt that is there. When I say just to cite it, it's just to help situate the context, that's all.
and look at, I'm not trying to be unfair to you. I mean, you weren't instructed to look at value in your instructions. So you were instructed to, you know, critique the approach that Stiglitz and Hutchings said, but you were given some assumptions to make, to use.
Mhm.
But if you look at paragraph 289,
Our main report, you mean?
okay, you know what? It just happens to be found, the excerpts. I thought I had it, I just couldn't find it. Tab 3 of the compendium.
Okay.
The decision,
Page,
page 18.
okay.
At
Yep.
paragraph 288, this is a reference to the Court of Appeal judgment. Are you with me?
Yes, I am.
The judgments provide that the treaties require the payment of annuities corresponding to a fair share of the value of the resources. And I'm going to stop you right there because I think you even write about in your report about how the Court of Appeal rejected the idea of fair share. The word fair.
Yes, I do recall that,
Yeah.
yes.
We would deconstruct the judgments into two possible promises for analytical purposes. The first is that the augmentation promise was a promise to share in the value of the land.
Yes,
The second is that a fair share was promised. So first value and second fair. And then the Court of Appeal continues, the first form of the promise to share in the value of the land is supported on the evidence and was woven through the trial judge's interpretation of the augmentation clause. So would I be correct, sir, in understanding that in your economic analysis, you, in your report, you did not take into account that there was a promise to share in the value of the land?
well, for us, the determinative text of the decision was the decision itself, which comes at the end and that we've quoted. So they expressed that. I know there's a lot of commentary here in
Right.
context, and they did make, you know, decisions in terms of an amended decision on things like fair and so on. But we went directly to the text of the decision. And I mean, net crown resource revenues can be seen as sharing in the value of the territories. It's
Well,
just,
it's sharing in part of the value, but it's not the value of the territories.
and neither are the economic rents. Right? It's the total value of the territories is bigger than the economic rents,
Thank you.
but the court landed on the idea of net crown resource revenues.
Okay. If you would have been in, and this is a hypothetical, if you would have been instructed by the defendant Crown to consider the value of the treaty territory in your analysis, would your opinion have changed?
Um,
Again, it's a hypothetical.
Yeah, no, that's fine. My opinion would not have changed, and I don't believe that sorry, I keep saying that, I apologize, that Dr. Mintz's opinion would change. We had a very common understanding of, you know, our commentary around economic rents was absolutely consistent and shared. Unlike some that I said, we focused on different elements of it. But if the instructions were phrased differently, I don't really think our report would have changed in any substantive way. We would still, consistent with the instructions that we receive, we would have been guided in large part by the decisions of the court.
Well-
And I don't see the decisions of the court as being inconsistent with broader instructions. In other words, when David Hutchins did his report, he used net crown resource revenues. And when they co-authored a report, they used economic rents. And I think they intended both to be sort of valid ways of arriving at compensation. But their reports, of course, were guided by your instructions, just as our reports were guided by by Canada's instructions.
Maybe I could get to the issue this way.
Okay.
As a hypothetical,
Right.
if the judge in this case decides at the end of the day that the value of the treaty territory is a relevant consideration, would you agree that an approach that tries to figure out what the actual economic rents were, would it be of at least some help to the court in deciding what the compensation should be?
I think that the economic rents approach that the authors took is of some value. I wouldn't discount the value. I mean, I think it helps inform her decision. Whether she actually follows that or not, at least she has various opinions of experts on the best path to take. And so when I say inform the decision, I'm not saying that that should be the path taken, because I do not believe that it should be the path taken. But I see no harm in having that analysis done. Any alternative ways of arriving at the appropriate level of compensation presumably are useful.
Justice, I was about to approach a new area. I think it would be a good time to break for the day. I do not have more than a day's worth of cross-examination. I'm reasonably confident that myself and Mr. Bass, on behalf of the group of 7, will be able to likely complete our cross-examination sometime shortly after lunch tomorrow at the rate I'm going.
Very good. All right, then we'll break for today. Sir, I'm going to remind you, you probably have already been told.
Yes.
That during cross-examination, you're not to discuss your evidence with anyone.
Yes.
Mr. Schachter may invite you to take the compendium home. I'm not sure.
Yes, you're free to take the compendium home and read it. I don't know that I'm going to be referring, I can telegraph to you that I don't think there's much in there that I'm going to be referring to. It was mostly for the articles that Professor Mintz had written, but I might take you to 1 or 2 of his articles. So you're quite welcome to take it home if you want to ruin your evening.
Well put. Thank you. Thank you. No, but I do appreciate that. Thank you.
All right. And
I just might mention that it might be time to address the copyright issue.
all right.
I guess we could do that off the record, though.
On the record is better.
Okay, we've discussed, Mr. O'Riordan, that your reports and the reports of the other experts will become part of the public record because they've been filed and will be archived. Do you have concerns about waiving copyright in your reports?
I don't personally. I would consult with our legal people at Ernst & Young, I guess, where I'm employed. I don't know a precedent for that. I have no idea, but no, I would have no concern or objection. And
You're the author.
Hmm?
You're the author.
So
You
I
have the last word
I have
here.
the last word. Thank you. Thank you. That's helpful because
Yeah.
and you
Just take
guarantee that I won't be fired if I
Can't say anything about that.
Oh, it's too bad. Thank you.
We have had all of the experts in this trial waive their copyright because we recognize the value of the collection of data that has been collected.
Especially in some of the other ones, I can see that, and I don't anticipate any sort of pushback from legal, but I just always go there. So
In the meantime, we've got this. Thank you very much. All right, we'll break for the day and resume at 10.
Yes.
All rise. Oh, yeah, oh, yeah.
No, no, no.
No, I thought that's the long list.
Shadow